Free the jury. What's going on, Boost guys? I legit still have to figure out how to turn the comments down. I gotta figure out how. Hey, is it Kia? Hey, Kia. Hey, Beta. Hey. I thought y'all would be back. Yeah, I had to take an hour break, but now we are back. Taylor, you're the little sister in my head. I love it. I absolutely love it. Grand Rising. Kia like the car. Yes, girl. I got a Kia. I drive a Kia. I gotta tell you right. It's my second one because I had to off my first one, but I love my car. My car is the best thing that ever happened to me. Well, it's not the best thing that ever happened to me, but it's one of the best cars I ever had. Hey, Corvetta. So y'all, I still have to figure out how to turn the comments down. I Googled it and I just don't know what I'm doing wrong. I don't know what I'm doing wrong. I gotta figure it out first because clearly I ain't doing something right. They say the comments too fast and I don't know what I'm doing. Yeah, I know I'm new to YouTube. Hey. Shout out to Kansas City. Shout out from Kansas City, Missouri. Hey, what's up, cousin? You know I'm in St. Louis. St. Louis, Missouri in the building. St. Louis, Missouri in the building. Hey. Okay, so the settings button are in the upper right hand corner. So I'm on StreamYard. So can I do it through StreamYard or do I have to do it from Rachel? Do I gotta do it from YouTube? Hear me out. Help me out. Okay, wait a minute. Let me go back now. I do too. I seen it on the. I do too. I see it on of the mods do it, but I haven't figured it out yet. From YouTube. Okay, y'all. Y'all gotta talk me through this. Y'all know I'm trying to figure it out. How the heck do we cut the comments down? Okay. Shout out to the 33 people that's watching from YouTube. I appreciate y'all. Make sure that y'all hit the like button. Okay, let me see. I'm struggling, y'all. Community moderation. What's this? Settings. Okay, no, these the moderators. Y'all, I'm lost. I'm lost as hell. Hey, y'all. Now that I figured out how to lock my screen on YouTube. Okay, y'all got to teach me how to cut the comments down. Where's Joy at? Somebody ping Joy. Tell Joy I'm in desperate need of assistance. Okay, because this is the chat, but you can clip it and the analytics are on here. Hey Taylor, they say hey Taylor gang. Yeah, I don't know how to cut the dag on where Chat GPT at, because it'll tell you something too. Let me get on Chat GPT and see if it'll help me, because I don't know. Chat GPT. We're about to talk about it because I know Court about to do his thing. Court about to be back on. So We got to talk about it. We got to go through and discuss what was talked about earlier. But I also need to figure out how to cut the comments down. Crap. Yeah, I feel like I suck at this. Hey, look for comment settings. I don't know where they are. And so the comment settings, right? I look for them on YouTube, all right? Just make sure. Hey, Rain. Thank you, Beta. Community. Go to community. Okay. Okay. I got community moderation. And then it goes to community. It got approvers, what they can do, block words, block links, default. Let's go to defaults. Comments on your channel. Channel guidelines. Okay, I like that. Be civil, be respectful, questions are welcome. Okay, I didn't know I could do that. I like that. Challenge the argument, not the person. Baby, if they could have told that to the state, they probably would have left. Advanced settings. Okay, yeah, I'm still looking. I'm just trying to cut the comments, turn the comments down because I know it's not on her, y'all. It's not on her. Like, I don't see it, friends. Default messages in live. Okay, community, default messages in live. Hey. I have to give you the utmost respect for staying very professional and keeping it real with all of us. Oh, thank you. Then look for messages in live chat. Come through, Shay. Come through, Shay. Okay, I'm gonna try it again. Community. Go to community. Leave. Okay, I'm gonna come back to the chat. Okay. Yeah, Shay trying to get me together. But something happening on the screen. Okay, here we go. I'm back motion. I'm back in motion. No, I don't want to do that. Thank you all 61 of y'all for watching. I'm trying to figure out how to cut the comments down. But when I click community, it's just community moderation. It don't just say community. So I don't know what I'm doing wrong. Let's go to settings. All right, settings, your channel, add or manage. Okay, playback and performance is not giving me what I need. These aren't giving me what I need. Those aren't giving me what I need. View advanced settings. No, it's not on here, y'all. I can't see it. This sucks. I'm sorry. I don't know how to cut settings, community, default messages, then live chat. I'm trying so hard, y'all. We got 20 minutes. If I don't get it in the next couple minutes, I'm sorry. We just gonna have to move on because we got stuff to talk about before. And I click community from my live though, right? I gotta go to my live on YouTube and then click on it. These are notifications. All right, community. Here we go. Community. From community, click on what my girl say. Hey, Taylor Gang. Default. From community, click on default. Okay, maybe this is the wrong community. Upload defaults. Comments on. Oh, community defaults. Okay, so when I get here, it just says comments on your channel. And it say on. So when I go to default, y'all, it don't give me the option to change the speed. Look in your YouTube studio. That's where I'm at too, Shay. It don't give me the options. It's just when I get to default messages in live chat, it's just a checkbox that say hold potential inappropriate chat messages. I don't have anything else other than that. It doesn't let me set a time. It does not let me set a time. Feature eligibility. Okay, well, I tried, y'all. Hey, everybody. So what you trying to do? I'm trying to slow down the comments in the chat. Everybody said they go too fast. So I was trying to slow it down because I don't want I don't want my mods to be in there working to save their life. So if for whatever reason, y'all feel like the comments are going too fast, just don't even worry about it, y'all. Just wait a minute till people slow down a little bit. Just wait on the people to slow down. Because Taylor don't know what she's doing for real. Wait a minute. Okay, it says comment moderation. Don't hold any comments. Hold. Okay, yeah, that's the only thing that it gives me, y'all. It don't let me change the speed. Let me try one more time. I need to log in. Oh shoot. Okay. Oh, enable the slow-mo. I have to do it through while streaming. Click on the 3 dots. Okay. Okay, it just don't give me the option. So I'm not doing anything wrong, y'all. It just, and I know I'm probably losing people because I can't stay focused, but it don't give me the option to slow it down. I can add timestamps. I can see the participants. I can pop the chat out. Yeah, but I can't. Okay, I can't do it. So they don't give me an option. Customization option, then enable slow mode. You should choose between 1 and 300 seconds. Should be under message delay rule. Live stream, click edit, click custom. Okay. Live stream. Okay, because I can see it, but it's not. Thank y'all for being patient with me. I appreciate it. No. Okay, so I got it up here. She said, no, it's okay. It's okay. Message delay. Customization option and then message delay. Make sure y'all like it live, even though I'm not talking about anything. It's just, it won't even let me go into the studio. You know how, like, yeah, I can't do it, y'all. I'm gonna have to have my nephew come over here and help me. Yeah. Or my nephew or a cousin or something, because, baby, I don't know. Now I'm showing my age out here. All right, well, I tried. Hey, Joy. I tried. I really did. Because I wanted to slow down the comments, but just if you are a moderator, just you got plenty of help in the chat. If you're a moderator, you got plenty of help in the chat. Just don't feel like you gotta hit everything. Somebody will pick it up. If they don't, they don't. It's okay. It's all right. It's all right. All right, y'all. Now, this morning we seen a couple of arguments. I feel like it's so dark in here. Like, I gotta get comfortable. It's too light. All right, so we heard a few arguments this morning from Doug, and we heard arguments from Max, and then the state. I can't wait for the trial to start right now. We heard arguments from Doug, from Shart, and the state. So I want to run back. Taylor gang in the building. I missed the beginning of Doug's argument, so I actually want to run it back. And I know court get ready to start in 10 minutes. So I'm going to spend this 10 minutes catching up on the beginning of Doug's argument. So
Good morning, Your Honor. Good morning. Let me begin just by stating that Mr. Shart and I last night went through a number of the predicate acts and overt acts that are in the indictment. And we've kind of made a detailed list of those predicate acts that we do not believe have been presented at trial.
Okay.
And I'm going to let Mr. Shart speak to that when he makes his motion orally this morning. I join in all of those that he does. And we're moving for a directed verdict on each of the counts against Mr. Kendrick, counts 1, 2, 50, and 57 through 63. And I'll go through each of those in order.
All right.
We're also moving for a directed verdict as to those overt acts that are before the 5-year date, before May 10th of 2017 in the indictment. Based on where we're looking at the jury instructions and the law, my understanding is that the jury is going to have to find at least one overt act that occurred after May 10th of 2017.
Right.
So I believe it would just be extra work for the jury and potential confusion if they were to sit there and go through each of the overt acts before May 10th, 2017. I understand that the state is allowed to put those into the indictment for a number of reasons. I understand that they like them in, or they want them in there in order to be able to quote unquote tell the whole story of the alleged racketeering activity. But since none of those overt acts can be used to support any racketeering conviction, I don't believe that those overt acts prior to May 10th, 2017 should be before the jury for a decision.
So yeah, it can be all or partial.
Those are the different counts. As to count 1, Your Honor, the RICO count, in that situation, in that count, I don't believe the state has shown evidence upon which a rational trier of fact could find an overarching conspiracy seeking to achieve an overall common goal as required by the law. The state has shown a number, quite a few, I would agree, a number of individual acts they've presented. They have presented a number of crimes and alleged crimes committed by co-conspirators. But I do not believe that they have presented to this jury any form of an overarching conspiracy that would tie those acts together. The second part, I don't believe that the state has presented to the jury an enterprise that would be required, at least a criminal enterprise. I do appreciate that perhaps they don't have to show that the enterprise was criminal in nature. So I'm not going to spend a lot of time on that. I don't want to take up the court's time. I have some things in my written motion. Third, a pattern of racketeering activity is required for the RICO. This pattern, as you know, requires two predicate acts. They have to be within 4 years of each other. And the key that I want to focus on is that these acts have to be interrelated. And it's the interrelated portion of the statute that the state has not shown for the jury, and that a rational trier of fact could not find. Again, after watching this trial for a year, it's clear that the state has put on evidence of various crimes and alleged crimes. They've put on witnesses. They've had testimony from individuals that are alleged members of this conspiracy that have taken the stand and admitted to committing particular crimes. But they haven't shown at all that these crimes are interrelated. In fact, when the witnesses have taken the stand and they've been questioned, in response to questioning, they've stated, I would say universally, I mean, it's been a year, so I don't know that I have everything in my head, but I believe they've stated universally that they committed these crimes for themselves. If they sold drugs at a gas station, it was to get money for themselves. If they robbed somebody, it was to get money for themselves. There's been no demonstration that this was interrelated at all. There's been no demonstration, for example, of money flowing up and down the organization, and they could have attempted to show that. They could have subpoenaed financial records. They didn't do any of that. It's as if the state believes if they just show a tremendous number, and I guess we have close to 200 acts, if they just show a tremendous number of different acts, that's sufficient. And it simply is not sufficient. They can try to argue interrelatedness, and I am sure that they will, but they haven't demonstrated that for the jury, such that a rational trier of fact could find the interrelatedness that's required for those predicate acts. Regarding count 2, the murder of Donovan Thomas, again, it's been a year. I could be leaving things out, but from when I have looked over the evidence that's been presented in this court, what I have seen them present, the state present, is Mr. Kendrick at a Texaco station inside of a Pontiac. And inside of the Texaco station, this Texaco station is a block from the location of the murder of Mr. Thomas. And they show Mr. Kendrick in and out of the Pontiac. They show him in a conversation with someone that may be in an Infiniti. But when Mr. Kendrick leaves the gas station, he's in a Pontiac. There's been no testimony at all, nothing, no video, no evidence that Mr. Kendrick somehow moves from the Pontiac into the Infiniti. And the Infiniti is what is alleged to have done the drive-by shooting of Donovan Thomas. There's been testimony from the state's own witnesses. I believe they presented an Infiniti identification expert that was able to identify the car that goes by as an Infiniti. It is not a Pontiac. Mr. Kendrick is not in anything other than a Pontiac. What else is the state presented? They have interviews that various individuals gave with law enforcement. I believe they have interviews that they presented in the form of video of Kenneth Copeland on June the 10th, 2015, speaking with law enforcement. They have interviewed, they have the plea agreement from Mr. Sledge. And by the way, that plea agreement from Mr. Sledge does not identify Mr. Kendrick specifically. And they also have Mr. Zachary's interview with Detective Thorpe. But in the case with each of those witnesses, when they've gotten on the stand, and the Sledge one is less important, I'm not going to focus on that. But Mr. Copeland, and Your Honor saw this, repeatedly told the jury that he lied to the police. He said anything he needed to say to avoid putting on that blue jumpsuit that Mr. Sharp so desperately wants to bring into the court and show to the jury. He would finesse the police. He would tell the police what they wanted to hear. He would sprinkle grains of truth into his stories to lend them credibility with the police officers. But when he took the stand, he completely renounced everything that he said previously. Mr. Sledge, as you well know, also renounced much of what was in his plea agreement, although again, that plea agreement does not focus or even, I believe, mention Mr. Kendrick. And then again, Mr. Zachary renounces what he says on the stand. So I think that a rational trier of fact could not find that Mr. Kendrick had any involvement in the murder of Donovan Thomas.
I do want to add to that, because even though Doug did not or is not planning on putting on a case, shout out to Thugger Daily. Everybody say shout out. Everybody say what's up to Thugger Daily. He probably not watching, but shout out to Thugger Daily. But he actually did post the motion where they were going to introduce Yak's alibi. So Yak actually had an alibi of being with his girlfriend the night of the unaliving of Donovan Thomas. So even though I want to call it out, because even though Doug didn't bring that up, it states facts. Or I'm not gonna say it states facts, but it speaks volume that Doug feels like he doesn't even need to bring in Yak's alibi, because they've done a terrible job of trying to prove that Yak participated in that unaliving. So let that sink in. Let that sink in. Doug is saying, look, this all the evidence that you got. I don't even got to tell you what my client was, because you didn't put my client there with these people. You didn't provide anything of value that I even need to speak on. Like, if this is what you got, then that's cool. Another thing that I want to bring up is that I saw Brittany's comment in the last chat about the possibility of Max Sharp putting on a small case in chief after the directed verdict comes back. And so I guess the question was, could he do it? Yes, he can do it. If he decides like, yep, I want to put on a small case, he could. But I also did hear Doug say that he and Max got out their cases over on direct. Like, they were able to present their cases through doing just a regular, they were able to present their cases doing regular cross-examination. So if they present it fully, I think regardless of if, the directed verdict or what the directed verdict outcome is, I think that these guys are still going to lean on the case that they've presented, because they've already poked enough holes. I do wish Doug would have presented his alibi just to be safe. I think that's fair. They don't have enough to prove who did that. I agree with that as well. My question is, how can they charge him for the stuff in the house if he wasn't found inside? And I mean, and that's the whole thing, right? That's the whole point of you charging him with this crime, is for you to present the evidence to say he was in the house. It was their duty to present that. And in my opinion, they failed. You failed to do it. You didn't. You failed to do it. You did not. And I'm gonna actually just speed the chat up because I don't want us to miss when we start. So I'm just gonna go to live view, and we're gonna wait for court to start. But that is exactly what they're doing here. And basically, you could get a grand jury to indict pretty much anything in Georgia from the looks of it. And just getting that past the grand jury allowed them to charge them. So we're gonna see what happened. We're gonna see what happened. And it's not just that he was in possession of it. It also reads that he was within arm's length of it, or arm's reach of it. And we got to remember that Yak is a felon. He is not supposed to be around weapons at all. He's a felon. So you got to take that into consideration too when you think about why did they charge him. Yep. This is really blowing me. Brittany is upset about this, y'all. Brittany is upset about this. Yeah, the affidavit is crazy to me. The affidavit, are we talking about the one that we actually saw on yesterday? Because I got thoughts. I got thoughts on the affidavit that we saw yesterday. I don't know if I shared any of my thoughts, but I found it interesting that she sat there and said she doesn't take notes because she makes lengthy affidavits. And then we get the affidavit, and it was literally a blurb. It was one of those emails that you're seeing when you don't want to have a meeting. It gave very little. And so I found it super interesting that Max Sharp did not bring up the exhibit of the affidavit. He let the state do it, and I think it killed Viverito's. I think it killed her credibility even more. I mean, her credibility was already gone when Doug got up there. But when they put their affidavit out, I said, look here. It was a blurb. It was literally one of those emails you send when you don't want to have a meeting. It was just enough. It was not detailed. All right. Back into the comments, y'all. Miss Tasha, yeah, we gotta keep Miss Tasha lifted. We gotta keep her lifted up in prayer, y'all. Yeah, I think they need to have a little bit. The standard needs to be raised on grand juries because they can indict anything at this point. But he wasn't. That's why she asked for the pictures. They are not in arm's reach except in the picture on the phone.
Discover your new Acura right now at Frank Leda Acura. Come lease a 2025 Acura RDX for $429 per month for 48 months. Now during...
And honestly, they still failed, because if you remember, Black, at the end, they still failed to present anything. She was asking her, show me the pictures where everything was before stuff got moved around. I feel like they didn't do that. And that was a part of what Doug said on when he got back up to kind of close out his argument on it. And get a judge to sign off on the affidavit without any real evidence. Talking about 24, he got 24 million and he putting it on people's heads. Girl, stop. It was an automatic reply. Sheena, it was definitely given out of office. It was definitely given out of office. I love that. It doesn't work like that on the Fed side. And when there's multiple in the house, it goes to the owner. And Thug took those charges. Absolutely. He did take those charges. The jury is supposedly not supposed to know that, but we'll see. Without the please advise on the end. You hear me? It did not say regards, nothing. It was just like, yeah, this is it. This is it right here. The fact that she stood on bringing it to the judge was mind-boggling. Oh my God. I said, girl, you out here telling the people that you would mislead. You telling the jury that you would mislead a judge. Like at that point, it was okay to agree with something that the defense could have used. She didn't like the defense so much that she refused to give an answer that favored them at all. And it just made her look horrible. one of my favorite witnesses, and even though he came at the end, was the gunshot residue expert, because you could tell he had no emotional attachment while he gave his testimony. He answered everybody's question, same demeanor, same tone, through and through. He did not switch up because it was the defense or because it was the state. He didn't switch up because anybody was trying to contradict his job or downplay his role in the work that he do or anything. He was one of my favorite witnesses, and if the state had more witnesses like the GSR, they might have did a better job. The case might have been presented differently. I know I'm behind on comments, but I'm gonna try to go fast. Yes. No blackouts today. All right, y'all, we back.
First, with regard to the ruling on the motions for directed verdict. So both the state and the defense requested and have gotten a trial in this case before a jury. Is not before the court as a bench trial. So that means that this court is not the trier of fact. And the standard, as you all know, for a motion for directed verdict is not the beyond a reasonable doubt standard, that what the jury is going to be determining the facts on when the case is given to them. The standard at the stage of motion for directed verdict is that all of the evidence is to be viewed in the light that is most favorable to the prosecution, and doing it in that way, looking at it in that way, is there any evidence from which a rational trier of fact could find the essential elements of the crimes that are charged. So with regard to the motion for directed verdict on counts 1, 2, trying to do these in order. Now, let me just do it this way. I am denying the motion for directed verdict on all counts except I'm granting a motion for directed verdict as to count 59, count 60, and count 62. I do not believe that the elements of
Let's go.
that, even viewing in the light most favorable to the prosecution, there's evidence upon which a rational trier of fact could find the essential elements of possession of those particular items. And let me say that with regard to counts 1, I'm sorry, not count 1, counts 2 and 49, again, is not a beyond a reasonable doubt standard that the court is required to employ in determining a directed verdict as to those counts. I understand the arguments, but it is up to the jury to determine credibility of witnesses, and it's up to the jury to determine what witnesses or what parts of testimony they might believe and what witnesses or parts of testimony they might not believe. So if there is evidence presented that a jury chooses to believe, which is how I have to take it in evaluating this, I have to evaluate it as though the jury is going to believe whatever is most beneficial at this point to the state's case. Which means they could believe everything that Mr. Copeland or Mr. Zachary said that would support the state's case. And frankly, they can disbelieve even an expert's testimony. And so I just wanted to add a little more with regard to what my reasoning was as to those counts. So that's, y'all know now what it is that you need to be preparing for closings. And I think unless there's anything else on those matters, that we can turn to the hammering out the rest of the jury charges and sorting out the verdict form. And I appreciate that y'all seem to have been able to determine for a lot of the overt acts, which there is not any evidence of. And so obviously those will get redacted out of the indictment. Oh, let me also say with regard to those gun charges that we talked about earlier, that I am granting a directed verdict with regard to the greater of those charges on the 133. The state even admits they don't have all of the elements for that. So those will be charged as the lesser. It looks like that Martinez case provides that even over a defense objection, the state is entitled to get the lesser charge for those counts. So that's why that's kind of, I guess, a grant of a partial directed verdict as to those counts. And those were the, well, y'all know which ones they were. I don't have them right in front of me. What were they?
52, 64, and 61.
Okay, thank you. All right. So I haven't yet seen the proposed charges on the crimes that are set forth in the overt acts. So, Mr. Atkins, we did get, there were some additions or changes with regard to the state's proposed RICO instructions, but have you sent yet the crimes that are just set forth in the overt acts?
The pattern instructions, Your Honor?
Yeah.
Yes,
Okay, maybe we just missed that.
I titled it, Your Honor, proposed, I think, supplemental jury instructions.
All right, well, Ms. Persfield will look for that. I know there are a couple of things we need to circle back on the non-RICO part of the jury instructions, but let's do the RICO part first, if you don't mind. And I keep further editing my proposed RICO jury instructions. So y'all have the latest, I'm not going to say greatest because it may not be, but the latest version of what the court is thinking about charging. So if we want to open that up and kind of start there, and then I'll listen to whatever anybody wants to suggest should be in or out or said differently. Now, Mr. Atkins, I wasn't quite sure I understood your teal. I didn't know if you were saying, oh, the court struck through these and we think they should be included, or what exactly the teal comments were.
Your Honor, the teal, I tried to capture either items the state believes
Okay.
should come out
All right.
or words that the state has.
Okay, so we maybe just, as we walk through, you just bring them up to me as we get there. All right, so if we want to all get to that document.
Mr. Floyd is going to take the
Okay.
lead on this part.
And, Your Honor, since you just emailed us, is it all right if I remain seated because I'm not going to
That's fine.
screen? And
Yeah.
are we going to go through what the state emailed to you first, or are we going to go through what you just?
What we're going to go through is what I am proposing, and then to the extent that y'all want to add or subtract or modify, y'all tell me. So I can open up as well. I've got multiple screens up here. The state's latest proposals as they modified them, and then the defenses as well. I think those are the same as they were a couple of days ago.
Okay. Well, Your Honor, since we had submitted those, I can go through those and explain what our thinking was.
Okay.
And the first one is, I'm going off of.
Let me find it first, if you don't
Excuse me,
mind.
Mr. Floyd, which document are you referring to?
I think it's something Mr. Atkins sent us. Is that right, Les?
Well, that's
Okay.
not.
One we said last night.
Can you give me just?
Yeah.
It's called jury instructions RICO draft is what the reline for the email is. And then it's got an attachment.
Thank you.
I'm so petty, y'all. So I want to tell y'all how I was in this spaces one night and I was talking about directed verdicts and how I felt like Yak was gonna get some. Now I didn't get the
Okay. I didn't want to.
No, thank you.
No, that's not RICO, that's the.
I'm assuming the one you're referring to is the one. It came around 8:20 last night. Oh my gosh.
Talking about
Which one?
three documents. The court's version of the RICO charges, the one that Mr. Atkins sent last night, that was jury and, no. Sorry. That was the jury instructions RICO draft for Mr. Atkins. And then there is also, more recently from Mr. Atkins, the additional instructions.
All right, we can't hear anyway, so I'm gonna tell my story. But I was in the spaces and I was talking about directed verdicts and how I felt like the judge was gonna grant one for Yak. And this dude, his name DJ Poppy on freaking on X, y'all. He tore me down. He tore me down in there.
Mr. Atkins sent last night.
At approximately 8:20. That's the one. Okay, thank you.
That sounds about, that time sounds right. It certainly felt like about 8:20.
I felt like midnight.
And it's got yellow and red and teal, and multicolored. That's
It's,
the one.
it's a potpourri, Your Honor. Most of these, despite the color variations, it's pretty simple, I think. The first one that the state proposed some changes to state RICO conspiracy, and I noted that the court had said needs to be tailored to indictment language.
Uh-huh.
I took that.
That was really early on.
Okay, well, but I think it was correct too, because
Mhm.
what was there prior to any modification is just a recitation of the statutory language or something very, very close to it.
All right. So if you would do me a favor and looking at the state's proposal, do you feel like that captures everything that needs to get captured?
I think it does.
Okay.
And what we were looking to do is just remove language that is in the statute. but
Right.
Does not
Agreed.
apply to this case
Mhm.
as it's been charged and presented.
Okay, so,
It just simplifies it. That's
yeah,
all.
so I mean, what I'm proposing is the state must prove that the defendant, and then list out the elements, knowingly and willfully conspired with one or more others, co-conspirators, to acquire or keep money or other personal property through a pattern of racketeering activity, and that any of the conspirators committed an overt act to further a criminal objective of the conspiracy. So I think that gets rid of all of what was not applicable from the statutory language.
I think that's correct, Your Honor.
Okay. And then, you know, a similar thing for the subsection B.
Yeah, the
Okay.
only, we've been using the word tweak.
Mm-hmm.
In the language that tracks subsection A,
Yeah.
3, personal property,
Mhm.
money or other personal property, this may just be semantic. I think the statute actually says personal property including money, which includes money, but this starts with money. The statute starts with personal property. It encompasses money. It's not a big deal.
Yes. Money is personal property, which is why it says money or other personal property.
enough.
Okay.
And as to the elements of B, yes, I think you captured that as well.
Okay.
Your Honor,
Yes.
regarding this, I just had one issue as well. I didn't know
Sure.
Before we moved on, are you done?
I'm done with this, John.
Okay. Your Honor, I would ask for number 6,
Yep.
of the elements,
Mm-hmm.
since, well, I don't know, I haven't abandoned my argument, but if we're gonna allow all the whole list of overt acts on the indictment to go back to the jury, I would ask.
Well, not the ones that y'all decided there's no evidence of.
Right, but the ones outside the statute of
Yeah.
limitations, I would ask that, on number 6, it's committed an overt act on or after May 10, 2017, or
True.
within the applicable statute of limitations.
True.
Yeah, the only thing I'd point out is you've got that later.
I do.
And so, I mean, I agree it has to be somewhere. It's the question is where.
Well,
Well,
I mean, the idea with listing out the elements is when they're deliberating, they can go right to that and go, all right, here's what we need to be thinking about. So,
which is why I think Mr. Shart's
Yeah.
suggested edit is useful.
so I had written down the dates. It's like between May
It'd be May 10th.
10th of 2017 and May 9th of 2022.
It would be within 5 years of the date of the indictment.
No, but let's
Right,
give them the
which,
dates.
why not just give them the date? Why make them do math?
Yeah.
All right.
Nobody wants to do math here. We're all
The
lawyers.
calendar in my head was functioning properly.
Yeah. The indictment, the original indictment was what, May
May
9th? Okay, so,
If that captures that 5-year window, we have no argument.
okay.
But the indictment doesn't, the indictment says, said accused together with unindicted co-conspirators in the state of Georgia and county of Fulton. You mind if I said?
Go ahead.
On or between the 24th day of January 2013 and the 8th day of May 2022. So maybe the cutoff
Okay.
date should be the 8th day
So
of May,
then May, what would that be?
May 8th, 2022.
No, for the beginning, May
Oh,
9th,
it would be
2017.
May 9th, 2017.
Actually,
No,
because
I do
the
too.
indictment
May
came
10th.
out-
I don't think they're,
Yeah, the indictment came out May 9th.
and May 8th. And honestly, the dates don't, and I'm saying May 9th, 2022.
Your Honor,
Yes.
the evidence demonstrates the conspiracy continuing after that. The evidence that's been admitted demonstrates the conspiracy continued after that. That's
So what's the law on, is it within 5 years before the indictment, or is it within 5 years before the indictment?
it's before the indictment is what the cases say. I mean, if you look at when it's Conzo,
But
that's the case. and-
continuing on up until the jury gets the evidence.
Yes.
Well,
Oh.
I would disagree with that, just because it's specifically pled
yeah.
in the indictment. It says, in the RICO charge, it says, for the said accused together with unindicted co-conspirators in the state of Georgia, county of Fulton, on or between 24th day of January 2013 and the 8th day of May 2020.
Yeah, and with that, and with that specific date in there, I would think that anything after the 8th day of May 2022 should not be considered.
Um,
Thoughts?
Yes, Your Honor. The fact of the matter is that we did not allege that the conspiracy ended, was terminated, or abandoned. And the jury can look to subsequent acts as evidence as well. I mean, up to and including, for example, Mr. Copeland's testimony. If the jury concludes that Mr. Copeland was lying and that was in furtherance of the conspiracy, they could consider that. Case on that is State v. Cagno, C-A-G-N-O, 978 Atlantic 2nd 921. It's a New Jersey 2009 appellate case, which involved the untruthful testimony of a witness during an actual trial. And the court looked to that and said that where that witness was part of a criminal organization and the evidence indicated that he was lying to protect the criminal organization or any of its members, that could be considered even though it ran all the way up.
Do you have any idea how that case was indicted? Like what the language of that, if that,
In truth, Your Honor, I have not seen the indictment. It would have been indicted under New Jersey law in any event. So,
right?
I mean, that is, you know, I understand your question. But I think, I don't think there's any question that there is evidence presented and admitted in this case that runs past those dates.
Well, the state certainly could have elected to indict it in that type of fashion with language that's a little more open-ended. But the notice that we were given by this indictment and that they elected to put in here, we didn't pick this date, is the 8th day of May of 2022.
In addition, beyond it being cut off by the 8th day of 2022, it's our stance that any overt act that the jury's going to consider has to be pled in the indictment. And so they don't have any overt acts extending beyond that date.
Over here.
The fact that there isn't one after the 8th specifically alleged, although we do in the superseding, we have the 9th there. They have notice of that.
They do.
Acts 183, 183 through 189, the dates are given on those acts, and they are May 9th.
Yeah, Mr. Floyd is exactly right. They do have acts that are specifically listed in the indictment on May the 9th. But despite that, they still chose to put May the 8th in as the timing of the conspiracy. And it's the same way that they have overt acts that predate the statute of limitations that they've placed in there. I'm sure they have good reason for that. But you know, they could have additional things in there. So again, they're the ones that elected to place May 8th as the end date.
If I may just jump in, I'm under the belief, and maybe I'm wrong, Your Honor has granted a directed verdict for May 9th.
Not all of it, some of it, but not all of it.
Those overt acts would be coming out of.
No, because Mr. Kendrick, I mean, if they determined there was a conspiracy and there were other conspirators, even if Mr. Kendrick wasn't the one guilty of any of these, somebody who might be a conspirator could have been. All right, so I don't think that most of the times dates in indictments aren't material anyway. So I would think it's between May 10th, 2017 and May 9th, 2022. And I need to, that's all of the overt acts that are pled. So you're saying overt acts that aren't pled can support the conviction,
Yes.
if there is to be one, as long as they are within, what, 5 years after the indictment? There's
time limit
no-
afterwards. I mean,
It's
there's
just,
just overt acts.
Yeah.
I understand why the defense desires to put a box around this. The law doesn't put a box around this in the way that they are suggesting it. In fact, you might recall, Your Honor, a few months ago, we submitted a bench brief on this.
yeah.
And we showed you cases where convictions were affirmed based on overt acts that did not appear anywhere in the indictment. I mean, there just has to be an overt act. Overt act is really
Yeah.
evidence. That's really what it comes down to. So here, this evidence is in.
I just don't see how, and I understand conceptually, but how does the jury say, okay, here's the overt act that we're all agreeing was proven, but it's just something we heard in the evidence that how do we even know, how are we supposed to know what that is?
Well, as a general matter, I think, I'm trying to think of the best way to synthesize this. Again, it's evidence. They just have to determine that there was an overt act. And
that they all agreed to it.
That they all agreed to it. And, I mean, there's a million aspects of evidence in here. Actually, in a case this long, a million might not really be hyperbole, that they're going to look at, but we're not going to ask them, do they find that this car was the same, this gun was the same? We don't walk them through the inventory of evidence, exhibit by exhibit, and say, did you find this persuasive or not?
Yeah.
That's not.
All right, so can y'all come up with some language that succinctly and non-confusingly says had to happen by, the earliest, May 10th, 2017? That just makes it really awkward.
I just
So
also
I don't
need,
know how to say that exactly.
I just also need to clarify that I'm not trying to put the state into a box. I mean, this is a box of the state's own construction that they've crawled inside by setting this May 8th termination date, May 8th of 2022.
Maybe I should have called it a mini house. Anyway, I understand. Okay, Your Honor, the relevance of this, as far as I've understood it, is that they are finding an overt act within 5 years of the date of the indictment, because that's necessary for limitations.
Right.
That's the pertinent question. And I believe you previously had a charge that explained that. If I don't see it in these court charges, excuse me. Yeah, I don't see it exactly in those. The ones that the state had submitted, I believe there is one on it there. But the only concern I have, and it's not a huge one, is that as to item 6 on these two, you're going to be saying the same thing twice.
What do you mean?
Not a big problem.
What do you mean?
Commit an overt act and then the date. Commit an overt act after the date that is 5 years prior to the indictment. You would say it twice there instead of once in a statute of limitations related charge. That's all.
I don't know what you mean.
I'm sorry.
I don't know what you mean.
I thought what we were talking about, and I apologize if I've lost the path here, in item 6 is committing an overt act, and the request was after a specific date that would place the overt act within 5 years of the indictment. Okay. And I'm just suggesting you'd say that once in one charge that's related to statute of limitations, or you could say it twice in each of number 6 because they're identical. Committed an overt act.
All right, where's your statute of limitations language in the state's proposed instructions? Because I don't see it.
I apologize. Neither do I.
Okay, didn't think so.
There was, I'm thinking one, I know I've seen one, I guess it wasn't in this version. But the state does not disagree that an instruction that says the jury has to find an overt act within 5 years of the indictment is appropriate. That's fine. We're not disagreeing with it. It's simply how the exact language is crafted and where you place it in this sequence.
Well, I think it's probably easy enough to say committed and as number 6 to both of these, committed an overt act after May 10th, 2017.
Okay?
I would suggest, Your Honor, that, it's the law. So I think we definitely want to make the jurors aware of the law as they're judging this case and the correct law. I keep going back, we're giving them a long list of overt acts. And as lawyers in this courtroom, we're fully acknowledging that many of them, based on the date, cannot be that overt act. And we will not be back there to explain it to them. So I think we need.
Well, we can explain it to them before we send them back then.
Well, right, and I think we need, my point is, with the jury instructions, I think we need to make that very.
So we might
clear.
want to add something. Many of the overt acts
Well, I was saying.
listed occurred before.
Mr. Floyd seems to want to just
Alleged.
say it once and make us pick. What I'm suggesting is, we say commit an overt act, and then if we want to say within the applicable statute of limitations, and then.
I'm not going to say that. That tells the jury nothing. I am going to say committed an overt act after May 10th, 2017, and I'm going to say it right in that list.
Okay.
Isn't that what you were asking anyway? I mean, I know you wanted a,
It's
close brackets at the end of it,
That
but.
is absolutely what I'm asking, but in your charges,
Mhm.
I think it's important that we put it there. But in court's proposed charges, you also have a separate charge about the statute of limitations for overt acts. I'm pretty sure I saw that in your,
Oh, that was,
that was in the one that you sent a couple of days ago.
don't look at that. Look at the one that Ms. Parsfield sent to y'all about 10 minutes ago.
The one you sent today, it's in the second to last paragraph highlighted in
Yeah.
yellow.
And yeah,
Unfortunately, I made my edits on the one that was.
Well,
sent,
that's
so
fine.
I'm trying
That's
to,
fine.
Yeah, I'm trying to go back and forth.
But I agree with Mr. Shart that it doesn't only need to be in there one time. And if your goal of the initial,
it's not going to be in there just one time. And
Okay.
the language that's kind of at the bottom of the court's proposed RICO instruction right now, I mean, I'm thinking that it may be that those sort of paragraph language for count 1 and then the 4 or 5 paragraphs after that, that's going to be after all of the instructions when, we always say, you'll have a verdict form. I think this verdict form may be one that I actually hand out to them and say, and walk them through, and then kind of say, all right, look, here's how you're going to think about this. And I am going to tell them when you're filling out the verdict form, because right now, at least, I'm thinking I'm going to have them list the overt acts that they unanimously agree to.
yeah, I think that would be best, Your Honor.
And that I'm going to say during that part, at least one of these, to support a conviction, at least one would need to be after May 10th, 2017.
Yeah, I think that would be the best way to go. And especially because of how, even for attorneys, how complex this is.
Yeah.
That if you could walk them through that form in that fashion, that would be beneficial for all involved.
Your Honor.
Yes.
Get game day deals on Uber Eats. This week, it's buy one, get one French fries from McDonald's. All season long, Uber Eats has deals on your football favorites. Order now.
For indoor comfort in changing weather, get Crystal Rapid Response Heating and Cooling. Fast service. More
Details of the statute of limitations as it may fit into the verdict form. I don't think you want to do that here.
I'm
because
not
it
going to.
Interrupts the flow of the elements.
Agreed.
And then when we get to the verdict form, I have a point about what's.
That would be
discussed.
great,
I'll do
because
it- I can do it now, or I can do it.
don't do
later
it
when you
now.
want.
Don't do it now.
Okay, all right.
All right.
Not do it now.
Next.
All right. Under conspiracy, the last sentence, it may also be inferred from any evidence.
Where are you?
In last sentence. Last
On the
full sentence.
states proposed, where are you?
Following this person.
Okay.
I'm
I don't,
Okay, the charge begins with the bold
Yes.
conspiracy.
yes.
The second paragraph under that, which
Okay.
on my printout is the bottom.
Okay, yes.
All right, in the last line, it says after the commission of the alleged offense.
Yes, that is highlighted because that was the language that was proposed by somebody, and I don't know what that's supposed to mean. So what do y'all mean by that?
I don't know that this is what we proposed, but it
I
may
don't
have
know
been-
where it
may
came
have been
from.
picked up from language in other kinds of conspiracy cases. But I think here you could say the alleged overt act as opposed to offense, because some of them are offenses and some of them aren't.
I mean, I would imagine it was the state that proposed this.
It
I
may
mean, we
be,
could,
but I
just to be
understand your
less
concern.
confusing, just say presence, companionship, and conduct.
That's fine. And then we don't have to give it the temporal reference.
So, well, I don't know we need to say it at all because we've already said the nature of any acts done, the relationships, which would be companionship, conduct of the alleged conspirators, which would be conduct.
And so
So
are you
maybe
looking-
just ditch that sentence altogether.
and stop at criminal design?
So it would read, the existence of a conspiracy may be inferred from the nature of any acts done, the relationships, interests, or conduct of the alleged conspirators, and other circumstances which may disclose a common criminal design. However, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act.
Basically, if I know you and have a, all right, let me think about it. It's like,
Moving on.
If I could have just a second.
All right.
so it's like us being friends, and then me knowing that you
Okay.
are going to go do something is my participation
Second page.
for our gang. Is my
Mhm.
participation in the conspiracy.
So obviously, I'm not going to include in there the two sources. I just wanted to let y'all know that's where I got the definition of overt act.
I understand, and I didn't think that was going to be in there. But the modifiers open or manifest,
Mm-hmm.
I don't think that's necessary. I think it tends to be confusing because they're going to be left to kind of guess at what open and manifest is. An overt act can actually be inaction.
We looked at the case law that y'all cited in support of that, and we don't read the case law to say that. It was supposedly in Pasha.
Pasha says that a single overt act is sufficient. Yes.
Doesn't say it can be a passive non-act act.
Right. But
So where's that?
My main point is it doesn't say open or manifest. I can't remember.
I'm trying to define overt act.
Right.
And there is a definition of overt act in the Bradford case and maybe that was a conspiracy case and that's why I cited 1648.
My only point here, Your Honor, is that I have never seen that language used in a Georgia RICO conspiracy.
Okay, well, Do you have a definition of overt act? Because nobody knows what an overt act is. And to define overt act as an act in furtherance of the conspiracy doesn't define overt act.
I, guess
I mean, I'd love a definition.
All right, Your Honor, if we can have the opportunity to take a look at it, we may be able to submit something that does that work. I'm just concerned about open or manifest. They aren't self-defining terms. I don't think they actually.
If they don't help, then yeah, I don't want to use them if they don't help.
I'll just, if you give us an opportunity,
Sure.
we'll look, and if we can find something that we think contributes to clarity, we'll certainly send it to the court promptly.
There's the Black's Law definition.
That's actually the place I was thinking of. Generally, jury charges, I've looked at a lot of jury charges in connection with this and other cases, and I've really not seen this kind of language open manifest. I can't say that no court has ever used it. There's so many conspiracy cases out there. I'm just saying that I don't.
Well,
remember
here's
any connection with
an
any
act
of
that can be observed. I don't know that I can access Blacks on here. It's probably a paywall.
I can, once we've finished here, and I can check on that.
Laura, I know I've got an older Blacks in Chambers. Do you mind running to get it? I doubt if they've changed the definition that much in the last few years.
You probably haven't changed it since Blackstone.
Correct. All right, anyway, we'll come back to that.
Okay, also on page 2, the next thing the state had was the last line, which is just the modifying language naturally or necessarily done to further the unlawful enterprise. I think done to further the unlawful enterprise is sufficient. I'm not sure that naturally or necessarily adds to that.
Well, naturally might not, but I think something in the way of a modifier, because it's something that should not encompass, something conspirator X does that is just this random thing that might, but is not designed to further anything. I think is and we didn't make that language up. It came from some case.
Okay.
Sorry.
I understand. If it was just random, it wouldn't be done to further the enterprise. That's why I think done to further the enterprise captures what's necessary. The language in the statute is to effect the objectives of the conspiracy. There's no naturally or necessarily. And
I think it might have even been from a U.S. Supreme Court case, but we'll ask Ms. Perfield when she gets back.
There's quite a few of those.
Any weigh-in from the defense on this?
I'm sorry, Your Honor. I have 3 different versions of very similar documents.
I am so sorry.
So,
I know.
it's okay. Mr., if you could tell me, I got to
read it loud if that helps.
Well,
It's the bottom of page 2 of 5, the last paragraph in a document titled Judge Draft RICO Charge that we received.
They're all titled that, unfortunately.
I'm sorry?
I think
They're all
titled
labeled that. Rev 3, maybe it should have said.
It says when people conspire together in an unlawful enterprise, any act done by any of the conspirators to further the unlawful enterprise is considered to be the act of all of the conspirators. However, each conspirator is responsible for the acts of other co-conspirators only to the extent that those acts are naturally or necessarily done to further the unlawful enterprise.
I'm not sure about the need for naturally, but I believe that necessarily is an important word there.
I'm going to disagree with my colleague also.
We'll figure out the source of that language and come back to that as well.
May I go? I'm just going to try to jump in sequentially,
Okay.
so we can
Yeah.
go down this.
Yes,
order, I
yes,
suppose.
that works.
If I could go to the paragraph above that.
Mm-hmm.
No. Okay. 3 paragraphs above it.
To be an enterprise?
Here,
What's it say?
here the specific enterprise the state alleges is young side.
Oh, yeah.
I'm going to ask Your Honor to consider just taking that out. We're defining enterprise. I don't think it's
Without the ones like you working tirelessly to keep things running, everything would suddenly stop.
I apologize.
I'm going to object to, there's a paragraph, 2 paragraphs down from that, in determining whether an enterprise existed.
Yes.
I don't think we need anything after the racketeering activity, comma. I think it can say, in determining whether an enterprise exists, we may consider any evidence of a pattern of interrelated racketeering activity. Period, that's it. I don't think we need it, and such evidence may be sufficient for you to.
Yeah, that came from, I don't know.
Came from Turquette versus United States.
Yeah.
And Boyle versus United States. Straight out of Supreme Court language, and it's out of Martin versus State, which is Georgia Court of Appeals, adopting Turquette.
Yeah. It is confusing though.
Well,
I mean, it's like almost saying the same thing twice. I think the first time it's saying consider it, and then the second time it's saying it could be enough.
yeah, I think you, to simplify it, if that's the objective, you might just say, determining whether an enterprise existed, you may consider any evidence of racketeering activity. We'll stop there.
Oh, no, it needs to say a pattern of interrelated
Well, it
racketeering.
doesn't need to say a pattern and interrelated, so I can just say a pattern of racketeering activity, because when we defined it, it has to be interrelated.
And
Well, then if that's the case, could we leave in interrelated and get rid of pattern? If you only want one of those words,
Sure.
I prefer
I'm
interrelated.
fine with both of them.
Well, I am too, and that's my preference.
this is, the concern I have, Your Honor, is we're drifting into the elements of 1614(4)(b) and not C, because the state technically doesn't have to prove a pattern.
Well, it's not saying you do. It's saying you can consider any evidence that there might be.
I see. All right, fair enough.
Okay, in determining whether an enterprise existed, you may consider any evidence of a pattern of interrelated a pattern of racketeering activity.
I think just a pattern of racketeering activity. You're going to define
Yeah.
that term
All right.
elsewhere.
We've got the Black's Law Dictionary now.
Drum roll.
We definitely, the first one is not applicable. Number 1, an act that indicates an intent to kill or seriously harm another person and thus gives a person a justification to use self-defense. That one is not applicable. Number 2, an outward act, however innocent in itself, done in furtherance of a conspiracy, treason, or criminal attempt. So an outward act, I mean, it's okay.
I think
See actus reus, also termed positive act.
Outward act might
I think outward
work.
is closer. Positive is easily
Open.
misconstrued.
Yeah.
by
Positive is
non-lawyers.
confusing.
I mean,
yeah.
I think the word manifest was like, it's something that's actually done, but whether that's a helpful word for the jury is another story. Let me just pull up Bradford real fast.
So, Edward, unless you're saying like engaging in a conversation demonstrates the commitment, I don't believe that all the way through. Just because it's a conspiracy. So, like when they were trying to get the situation
All
with
right, so this is Bradford v. State Supreme Court 285 Georgia 1 from 2009. An overt act is one commonly understood to be, quote, open, quote, manifest, or, quote, public, and that is citing Black's Law Dictionary. I think that's just the definition of, it's a different Black's Law Dictionary than I have right now, but open, manifest, or public from Black's Law Dictionary 1990. Mine's probably newer than that.
Yeah, the most recent one is,
Mine's not the most recent one. It's probably from law school, but
all right, it's the best one.
it's the 7th edition, the one that I have in front of me right now.
I think we may have agreement that outward does the job. I think the fewer words that are used here, the better.
I think manifest can be confusing to a
Okay.
non-lawyer. So I'm okay with outward,
Outward.
unless Max disagrees with me again.
I don't know what manifest means.
So outward, yeah, outward is good.
Outward. Okay. Means an outward act.
At Harbor Freight, we do business differently from the other guys. We design and test our own tools.
If we made it any better, Your Honor.
All right. Now back to the naturally and necessarily. Ms. Persfield, do you remember what case that language came from? The under enterprise, each conspirator is responsible for the acts of other conspirators only to the extent that those acts are naturally and necessarily done to further the unlawful enterprise.
I agree, Edward, and that's why I don't know why I thought demonstrations is actually like doing something at that time when I read it, but I agree with you. That's why they're pushing the overt acts, because their demonstration is very small, right? It's the tattoo. It's standing on a car. It's a picture of you standing on a car. It's a video. It's your lyrics. So I 100% agree with that. I apologize.
Okay, we'll get back to y'all. Mr. Floyd, it's from the jury instructions from the APS case, which you touted to be the standard by which we should all be
I
measured.
think I did.
So I think
mention
we're
that things
gonna-
have- Things have evolved a bit since then.
I think we'll be leaving that in there.
All right.
Thank you, Ms. Persfield.
My plan is to not die on that hill. On page 3, Your Honor, definition of racketeering activity, the first line. I don't think or soliciting someone else.
Yeah, that's why it's
highlighted.
highlighted.
So
So that was where the teal stuff got confusing. I didn't know whether the state wanted that in or out.
I think we can take it out.
So
What
it's
we were
just
trying to
deliberations.
do is simplify it by not having you instruct on things that aren't.
Well, I don't believe there's any allegation or any evidence of solicitation of someone else.
Yeah, I don't either. Okay, so that would then just read, means committing or attempting to commit any of these crimes in the list. All right. Under the list, I think the states had use of an item with an altered identification mark. Do we have evidence of that?
Yes, Your Honor, it was the Trontavious Stevens had a firearm with a scratched off serial number
Okay.
that I think that evidence came in through an officer testifying about it.
I thought so. I just wanted to circle back on that one. And then all of your other teal things, again, I didn't know whether that meant
I
take
apologize.
these out, leave these in.
I apologize, Your Honor, for the teal confusion, but my intent was to, well,
Well, let me ask you this. If you look at the list as it exists in this draft, does that cover?
it does, Your Honor, and I actually, the burglary,
Right.
we do not need, that there was an
Okay.
allegation of a burglary on an overt act that we did not present evidence.
All
of.
right, we'll take that one out.
What about use of an item with an altered
Yeah,
identification?
we just talked about that one.
Okay, I'm sorry.
And Mr. Atkins is right. There was some evidence of that introduced.
Okay.
The possession or the use of?
The reason we, let me explain that change. Okay, sorry. Is that some of the drug-related offenses are broader than mere possession or use. And so we put possession or use in there because that's possession and possession of with intent to distribute. That's what's charged.
Where are we talking about?
We are in the list
Mhm.
of crimes, the last two.
Okay. Possession of marijuana with intent to distribute and possession of marijuana?
Right.
Okay.
And I think we meant to make this modification with related controlled substances that may not have gotten in there. But the same thing, possession of controlled substances, possession of controlled substances with intent to distribute.
Okay, so right now it's violation of the Georgia Controlled Substances Act. Do we want to
We can.
Article 2, and I assume that both codeine and cocaine are within Article 2 of, okay.
Schedule, cocaine's a Schedule 2, codeine's a Schedule 2 or 3. On memory. Yeah.
So then it would be what? Possession of codeine with intent to distribute is what was charged, right?
Yes, I believe so. I mean, the language about Article 2, that comes from the actual language of the statute.
Right.
That's written for lawyers, that's not.
Right. No, I agree. I just, okay, possession of codeine with intent to distribute, possession of marijuana with intent to distribute,
Then we have
possession of cocaine, and possession of marijuana. Okay. And then I still need, we're going to have the definition of murder anyway, and of the, we won't have the, I still need the definitions for all of these, the pattern language definitions.
Mr. Atkins, can you submit that?
Yes, Your Honor.
Okay, all right.
I'm not the runner.
Okay, moving on to pattern of racketeering activity.
If I, one
Yep.
other thing.
Sorry.
Based on your ruling, possession of marijuana could come out, your direct verdict argument. Verdict ruling.
Nope.
No, because there's code.
It's a,
Still over, sorry, my mistake.
I'm sure the
I agree
defense
with
would be
Mr.
happy
Floyd.
to have it out.
I agree with
but-
Mr. Floyd. They can come out.
Yep. I think he misspoke on that.
Do the current charges on the table, have this second paragraph with about the threats? That
Where are you?
I'm looking at,
Is it under racketeering activity or something else?
well, I mean, under we have racketeering activity,
Uh-huh.
and we define it, and then we have a second racketeering activity.
Right.
Also means any act or
Right.
threat.
Okay, I don't know. Do we have a threat that involves murder, robbery, theft, receiving stolen property, obstruction of justice, or dealing in narcotic or dangerous drugs?
We're gonna bring them homicide. Yes, for the caption of one of the photos. Yes, we do have, we have threats and we have acts.
Okay,
So, I mean, the any act or threat involving language comes directly out of the statute.
Okay, but we don't have a threat of robbery, theft. I don't even know what a threat of dealing in narcotics or dangerous drugs would be.
by God, I'm going to deal in narcotics.
We don't have a threat of obstruction of the officer. I don't know what a threat of receiving stolen property would be. So why don't we just say, and take what I would suggest, we just take that threat paragraph out, and we could just put murder or threat of murder.
Well, and then you would have what? Any act involving for the
Any
remaining
act
ones?
that involves murder, threat of murder, robbery, theft, et cetera, et cetera.
I think that can do, yes.
Okay. Thank you.
Great, thank
Okay. I'm actually changing it online. What else? So that takes us to pattern of racketeering activity, although we definitely need the definition of the underlying crimes somewhere.
You want to go back just a second?
Okay.
On the reference to controlled substances on page 3, the two specific drugs would be cocaine and codeine, possession with intent to distribute.
Okay, so what I've done is just like we listed the specific other things, I've got possession of codeine with intent to distribute, possession of marijuana with intent to distribute, possession of cocaine, possession of marijuana. Does that work? Okay.
All right, thank you. All right, but we did not, I don't think we tealed up page 4, which would take us to page 5.
All right, are there any issues for the defense on pattern of racketeering activity?
Yes.
Okay. And I've even got an issue on what I list as my element number 3. When it's only a conspiracy, there don't have to have been racketeering acts achieved. There might be, but there don't have to be. And so how do we deal with they've got to be within 4 years of each other?
I don't think it's relevant here, because the question is the contemplated objective, not the actual way it turned out, because that would be a substantive charge. I don't think there aren't any that are separated by more than 4 years.
Well, I mean, y'all were just arguing we've got the murder of Donovan Thomas in 2015, and then we have the murder of Mr. Drinks in 2022, right? Which is more than 4 years. And so assume that's all that they find is interrelated. Then what?
Those would be the acts that actually occurred. Right? And in a substantive case, that would be an issue. Right? But this is where we get into this whole problem of exactly what was everybody contemplating every moment in time in a case like RICO that tends to unfold over time. And so, Chamel's.
Celebrate Thanksgiving with love from Walter Knoll Florist.
All right, the drug charge. The drug charge. Like they would use that evidence for the RICO charge, y'all. That's why
Does not matter in that circumstance. there's certainly no Georgia case that says it does.
Well, are there any Georgia cases that deal with conspiracy assertions and not substantive that also talk about this?
Provision?
Yes, to me, this is the toughest issue there is in terms of figuring out what the actual law to charge is.
I understand the challenge, Your Honor, but again, the one thing that when you look.
Okay, so a lot of people were asking, why is the RICO charge or the drug charge coming in? Because they have to weigh that for the RICO. Like, it still comes in as a part of this enterprise organization. Like, they still get to get that evidence because of the RICO charge. He just won't be charged independently for possession of it.
The what ultimately happened test in here, I'll go back to the hypothetical. And I'll try to.
Well, I mean, I understand your hypotheticals. What I'm going from is the statute, which is what the law actually is, unless, further developed by case law.
I mean, the question is whether the conspiracy contemplates a pattern of racketeering activity. And if that pattern could take place within 4 years, I think that would be sufficient.
Right.
And we can't say that everything that actually happened had to fit that.
But how do we explain that
It's not a conspiracy case.
to the jury?
Now,
I mean, I don't think this needs to be mentioned to the jury, but if the court believes it does, the way to do it would be, I think, to say that they considered engaging in at least 2 acts of racketeering activity within 4 years of each other in furtherance of, and not make this a separate thing at the end.
well, so, Your Honor, on page 4 of, I think it's on both your drafts, you have an instruction, and I took liberty to propose some changes. So it might not be exactly how it is in your draft, but it says the state must prove, I added beyond a reasonable doubt.
Yeah.
that
I'm telling them that all of this is beyond a reasonable doubt. None of the pattern charges that have been changed say that every time. So,
Okay. And it says that defendant, and I took the liberty to say knowingly and willfully, agreed to join a conspiracy with the knowledge.
okay,
and
are we
intent.
back at it? I'm trying to figure out where I should go.
Mr. Short has jumped down to below the line of asterisks where it says
Okay.
4 count 1.
Okay.
But I think that this charge may be what we're essentially
Okay,
talking
go ahead.
about.
I
The
just
state
wanted
must
to know
prove
where to.
the defendant,
Uh-huh.
I added knowingly and willfully,
Okay.
agreed to join
Yeah, that
a
needs to be.
conspiracy.
With
with
the knowledge and
intent
intent is
that-
knowing and willingly, I think.
Okay. Yes, Your Honor, that one or more conspirators would commit at least 2 interrelated acts of racketeering activity, and then I think we're saying within 4 years of each other. And it seems like that charge would go to under where we're just previously talking. So
Okay.
we'd move that up. It seems to me.
And, Your Honor, I was not clear from this whether the section.
Y'all go follow my boy, Dear Woke Christian. Thank you so much. I appreciate that. And everybody who was gifted a membership from Dear Woke Christian, make sure you thank my boy. Go subscribe. And
I don't know. I mean, it's part of the instruction. I think it needs to get said. Whether it gets said here or whether it gets said when I get to the verdict form, I hadn't decided yet. I just think this stuff needs to get said. So I don't know the answer.
Okay, here's my concern is
Yes.
that to the extent you're restating elements that have been stated before, they're being restated in different language.
Right.
And that can be a source of confusion. I mean, the court, the way I was interpreting what the court did at the beginning of these instructions is you tried to make these as short and succinct and simple as you could, consistent with the language of the statute, and I understand that. But here we're kind of restating the same premise, but with different words. I don't know which set of words the jury's going to follow. That's my.
I mean, as long as they're not inconsistent words, it doesn't matter. If they just further flesh something out, that's fine. So if you think they're inconsistent, point that out to me when we get there, preferably. But I don't think more words is worse. Frankly, most of this language is from some version of what the state wanted at some point. But I mean, I was kind of thinking it would be when we're talking about the verdict form, but yeah, I definitely don't want to be inconsistent. That would be bad and confusing. Don't want to confuse, want to clarify. Okay, so within 4 years of each other. So back to pattern of racketeering activity. I'm back up at page 3,
Okay.
defining pattern of racketeering activity. Okay, but see, hang on. So we're defining pattern of racketeering activity. You need the concept that they have to be within 4 years of each other. And then they're not being found guilty of engaging in a pattern of racketeering activity if what they're supposed to be determining is, did they conspire to engage in a pattern of racketeering activity? But the jury still needs to understand what a pattern of racketeering activity is. So how about pattern of racketeering activity means 1, engaging in at least 2 acts of racketeering activity, 2, within 4 years of each other, 3, in furtherance of 1 or more interrelated incident schemes or transactions, and then explain what interrelated is.
I didn't mean to speak over you. I think that is easier.
Okay.
It flows better.
Yeah.
It actually flows better than
It does.
statutory language.
Yeah. Okay. All right. I think that's what we'll do then. So where does anybody have?
This is not in the teal edits, but we're doing this quickly, and sometimes as I'm reading it through, I recognize this is not the biggest deal in the world, but I think interrelated might be easier if you said interrelated here means acts that have, and then you pick up that same or similar. Because interrelated modifies acts.
Okay. Yeah, that is definitely clearer.
With regard to criminal objectives.
Hang on.
Sorry.
Interrelated here means acts that have
Yes.
the same or similar blah, 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 or that are otherwise interrelated. Is that what you're proposing?
It is.
Okay, I think that works. All right, next.
Here, as far as criminal objectives, you pointed out that as expressed in the indictment, there were some things that were not illegal, wouldn't automatically be illegal in some of the 5 categories that we listed, and you take 3 of them here.
Yeah.
We do not object to that.
Okay.
And I think this encompasses also everything that was illegal in the other 2 categories, and therefore it's easier for them to remember 3 than it is to remember 5.
Okay.
Does the court plan to give them a copy of the instructions?
Oh, yeah. I always do, even in a one-day burglary case. Yeah. Not that we ever try those, but yes.
Yes. Okay.
There's no reason it has to be a test of memory. I'm not, however, going to tell them that until after I give them the instructions because I want them to pay attention. Okay. All right. So now down to the kind of paragraphy language. My thought was that that would come not within these instructions, but at the very end when we get to the verdict form. But we still need to kind of walk through them and make sure that there's not anything that's incorrect or inconsistent that I'm saying. And Mr. Shart, you had mentioned, does the first one need to say, knowingly and willfully? And maybe I was thinking, and with the knowledge and intent would be the same, but it probably is safer to just say knowingly and willfully. Okay.
Is that additionally or in lieu of?
Well,
I'm sorry, what's the proposed revision?
for count one, the state must prove that the defendant knowingly and willfully agreed to join a conspiracy. And then I think it would maybe just say with the intent that.
This holiday season, give the gift of sport at Dick's. Score warm jackets and hoodies from the North Face, Patagonia.
Conspirator would commit at least 2 interrelated acts of racketeering activity within 4 years of each other to either get or keep money or other property or participate in the enterprise.
Okay, I don't object to that language, Your Honor. Thank you.
My only concern here, Your Honor, is that I don't know that we need a second statement of intent here. Knowingly agree to join a conspiracy.
I mean, if I don't say what the conspiracy is down here, I mean, we could join a conspiracy to,
I'm sorry.
do all sorts of things that wouldn't be RICO.
I understand. I think you're expecting me to say something I wasn't about to say.
Okay, sorry.
No, it's all right. Agree to join a conspiracy. I think understanding.
Oh, instead of with the intent?
Yes.
Yeah, understanding is much better.
Or maybe
Thank
with
you.
the understanding that. Either way. That way we're not giving them 2 intense standards in the same.
Understanding works.
With that change, I don't think there's anything incorrect in that, and I don't think it's really inconsistent with what you said.
Okay.
It's just kind of a restatement. My concern is that we're getting the following paragraphs get into, I think, them determining, walking through the indictment and determining, are we unanimous on this one, are you unanimous on this one, et cetera, as opposed to what we were discussing yesterday, which is just telling them, you have to be unanimous that there was an overt act, you have to be unanimous on which one it was. And you'll be telling them that it has to have come after a certain date. So that covers everything. This is frankly, part of my worry here is that we get a jury who goes in with a very, very long form, they get tired, they go through, they check off a few, and then they say, well, that's good enough. She said we only needed 1. And this only works if they go through the entire thing.
I mean, I'm not listing all of them on the verdict form, if that's what you mean.
Then I misunderstood. I was afraid that that's what it.
So what I was thinking about doing was saying like, I don't know yet, but defendant X did not join whatever this conspiracy is. If it's did not, that's the end of count one. If it's did, then potentially these are the interrelated types or acts of racketeering activity, or this is the pattern of racketeering activity, and have them listed.
But then now we've turned it into a substantive case, not a conspiracy case. That's my concern.
No, but
This is the pattern that they agreed to. You must then determine which interrelated types or acts of racketeering activity the defendant agreed would be committed.
Well, I don't,
They agreed that they would murder everybody, or whatever they might come up with.
all right. I see, I think I understand what you're is looking at. Problem is types or acts. I mean, are you contemplating that they basically have a menu and they check it off?
No.
And the menu is acts of violence, narcotics, property crimes. I mean, that.
I was gonna get input from y'all. I don't know.
Well, that might work. I mean, my concern when I read this was I thought we were back to the point where we were looking at a list that just tracked every overt act in the indictment. And I can see a lot of reasons why that could cause problems.
So it could either be, you must unanimously determine which interrelated types or acts, that one's still up for debate, of racketeering activity the defendant agreed would be committed, and then have them listed, or that interrelated types of racketeering activity would the defendant.
I think all they have to decide is that they contemplated committing interrelated acts of racketeering activity.
Well, they agreed to, not they contemplated it.
All right,
You could contemplate it and reject it.
fair enough. Okay. But that's really the question before the jury is, did the agreement contemplate what would ultimately have become a substantive violation? I'm very concerned about using the word act, because you can see how they could get all hung up on that. And that's not really what the conspiracy law requires the jury to determine is the specific acts. That's what we talked about yesterday. The federal cases I cited to you, they all say they don't have to determine which specific acts were contemplated, only the types.
But even those federal cases say that the jury has to be unanimous on the types of acts that were committed. You'd agree with that, correct?
Whatever the jury's deciding, they have to be unanimous. I agree with that.
And
All right,
unanimous on the types of
Don't
acts.
talk to each other. Got to
I'm
talk
sorry.
through me. That's just how it works in court. You know that. I know you didn't mean anything by it, but
I
it
always enjoy
sometimes
discussions.
devolves. I don't think it would with this particular crowd we have right now, but
Anyway, Your Honor,
yes.
I believe that the federal cases that Mr. Floyd cites would require the jury to be unanimous in the types of racketeering activity, and I think it would be necessary for them to indicate which are the types on their verdict form.
I don't think it's required.
Well,
trying to
shall we
figure
say
out-
helpful? I'm trying to also contemplate if there is, as Mr. Steele might say, God forbid, a guilty verdict in this case, and an appellate court is reviewing, I think without some tiny level of, I even hesitate to call this detail because it's so high level, but some guidance on the basis for the jury's verdict, that it would be difficult to review. And also, we would want to ensure that they are unanimous on the type. So if they indicate the type, that would ensure that.
Here's my issue with type. I mean, so let's say they don't decide, or the jury doesn't think, oh, they decided they would murder all. Let's say they think they decided, we're just going to hassle Lucci in any way possible. So we're going to steal things from Lucci. We're going to stab Lucci's mama. We're going to do X, Y, and Z. Those are different types of racketeering activity with the same victim. So it doesn't have to be the same type. And that's correct. So that's the wrong word to say.
And it's the one that crept into the case law, but I think
Yeah,
observation is
it's
correct.
wrong.
But-
And I'm sorry, y'all, I'm kind of like thinking through this as we do this
No,
because
no.
I've never done a RICO case before as a judge.
And I've never done one that didn't have a new issue pop up that I never thought.
Right.
So y'all just got me talking like, okay. I'm so sorry. So what I'm trying to do is explain to y'all what the hell is going on. So so again, y'all know that they are arguing how to word the jury instructions for RICO, right? And the issue that they're having is how do you basically convict somebody? And so Doug is saying that, you know, the jury has to unanimously agree on the type of basically crime that they are conspiring on, right? And that's going to be considered like the predicate act. So in this case, it could be like the stabbing of Lucci, which is the example that she used. So you have to, one, establish what type of crime it is, and then two, you have to show that people willingly participated in or tried to conspire in order to do this, right? And so what they're saying is that you can't, he's saying, well, the way that you worded it, you can't really list it like that, because if they check one and they don't go down to the bottom to check the other one, they're not gonna do it right. And Doug is saying, well, if they agree, they agree. And if they check the box, they check the box. Let's leave it at that, which is, I mean, in my opinion, a great argument. Because, you know, it's going to be a lengthy instruction anyway. But that's essentially like where they're going. They're trying to figure out how to word it in a way in which the jury agrees on what the conspiracy is, and then they also still look at the crimes to determine if it was done in furtherance of the game. So I hope that helps.
Up above, if we're not going to say what was it, then we've said the state must prove the defendant knowingly and willfully agreed to join a conspiracy, understanding that one of them would commit at least two interrelated acts of racketeering activity within 4 years of each other to do one of these two purposes.
Guess what? Oil change time again. That last mechanic took 3 hours. You will never.
Definition, you pick up the same types in there. I mean, it's kind of baked into the definition that you've already got in the instructions.
But, you know, we're in a situation where, and I understand it, where the state does not want the jury to go through and say, we find this act, we find this act, we find this act. And that's the same thing that happened in these federal cases where there was an argument you shouldn't have to find specific acts. And I think that's why the federal courts have gone to, okay, fine, you don't want us to look at these, to have the jury identify specific acts, but they do need to identify, I guess they went one level up to types of acts that occurred.
Well,
But was that a conspiracy case? I mean, as long as I'm saying you have to be, I'm sorry, that you have to be unanimous that they proved all these things.
Go ahead,
I
Mr.
don't mean to
Floyd.
interrupt you. To be clear, the cases that I was talking about yesterday, those aren't verdict form cases. That's where the request was that the jury be asked fill out a form that went through every single one of them. And they said no, and the jury was instructed on types, not that the jury filled out a form on types. We don't want to, it's not a, I don't want us to back into giving them an essay question. That's not what we ask juries to do. Juries say yes, no. And if we kind of open it up for them to express themselves, I think we're asking for trouble. There's a good reason why.
And again, I'm not requesting a essay from the jury. I just think that having them identify what is the type of activity that they have found, or I mean, it's not my preferred outcome, but some form of check the box, as the state may have indicated, perhaps just some guidance more than yes or no. And I appreciate that that's what the state would prefer.
Your Honor, I have an idea. We're all thinking out loud here a little bit. What if it is contemplated the commission of two or more related acts of racketeering activity in furtherance of one of the criminal objectives of the conspiracy? Because that would actually tie in to something concrete that you're already doing.
Say that again.
Agreed to join a conspiracy, understanding that one or more conspirators, himself and or a co-conspirator, would commit at least two interrelated acts of racketeering activity to achieve one or more of the criminal objectives of the conspiracy. The reason I say that is you're telling them what those objectives are, and those objectives encompass the substantive violation.
And is that a recommendation regarding the second to last paragraph on page 4?
Yes.
Could I ask what that proposed language is again?
Memory test.
To achieve
Well,
one or more of the criminal objectives of the conspiracy. Right?
Yes.
But where are you saying to put that?
Where you have 1 and 2.
Yeah.
Instead of sub 1 and 2, in either you just say acts racketeering activity to achieve one or more of the objectives of the criminal conspiracy.
Okay, so
And the reason I say that here is because those objectives contemplate the violations of A and B.
but how do I know? Does it even matter? Do I need to know which one they return?
Done because of Cotton 2.
Well, I don't know what that shorthand force or what does Cotman 2 say?
Cotton 2 said it is sufficient to prove either or both of the A or
But I don't need to know.
conspiracy to violate either or both of the A or B.
Okay, well, I know that, but I don't need to know which one or ones they found.
No, you don't. And that was exactly the question in Cotton. And
I don't think it should be the goal of the court to make the jury's decision as opaque as possible.
Well, I'm obviously not trying to do that.
I didn't want to imply that the court was.
see, that leaves one person.
Well, I'm not allowed to directly address you, Mr. Floyd.
So, can I?
Yeah.
So we were talking about, back up to that paragraph, the second to last one. And Mr. Floyd, if you could just help me follow your train of thought, does that affect what you're proposing in this second to last paragraph, does that affect the last paragraph on that page?
I think it removes the need for the second paragraph.
See, that's what I was concerned about, because the second paragraph still has unanimously and which interrelated types of acts. So I understand what that Mr. Floyd is trying to incorporate into the second to last paragraph, but it's still leaving certain aspects of the last paragraph out.
Well, I understand.
Is the state suggesting removing the last paragraph?
That's what I just said. I think it obviates the need for
Oh.
it. And remember that as we're discussing this, Your Honor, this all is coming after you have instructed the jury on overt acts. They understand what they have to find.
But they do have to unanimously find which types of interrelated racketeering activity occurred. That must be unanimous.
Well, they have to unanimously find that defendant joined the conspiracy, and then also determine what.
Right.
And Your Honor.
All right, I'm satisfied that they don't have to list out what pattern of racketeering activity they think anybody may have conspired to commit, as long as they unanimously agree that a defendant conspired to commit a pattern of interrelated racketeering activity. Is there any case law that they have to list it out if it's a conspiracy case and not substantive?
First, I'll divide my answer into two parts. Part one, Georgia, no. Part two, I'm not aware of any other jurisdiction that requires it, but certainly not in Georgia.
But Your Honor, this is my understanding. It's not just that they have to unanimously determine that, say, Mr. Stillwell joined a conspiracy and with the intent of a pattern of racketeering activity. They have to unanimously agree on
What it
is. Right.
Mm-hmm.
Like if some of them say, "Oh, he was joined for
Right.
theft," and the other.
Right. Okay.
Your Honor, I think my suggestion contemplates this because by referring back to the criminal objectives, we stated what those are. They only have to find that it contemplated two or more acts in furtherance of one of those objectives. And these objectives refer to specific types of criminal conduct.
Objectives and pattern of racketeering activity are not the same element.
I understand, but each of these says through acts of racketeering activity and then lists crimes. It doesn't just stop at objective. It says you're going to achieve this objective by committing these crimes.
So you're saying that if they find any of those, that any of it was done to further a criminal objective, that even if it was, let's take criminal objective 1, a count of murder and a count or an act of murder and an act of a threat of violence were what was contemplated, that would necessarily be interrelated because they would have had to determine that it was in furtherance of criminal objective 1, which is preserving, enhancing, protecting, blah, 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 which is a same or similar intent or result.
With the exception of the blah, blah, blah part, you said it better than I did.
Okay.
Yeah. Yeah, I think it's already captured there.
Yeah. thoughts?
We've been moving around a lot. Could I just hear the final proposal or what we?
Whatever you do it for less at Harbor Freight.
It's gonna be okay.
Floyd's is that in that first paragraph, that instead of saying to either one or two, that it would just say within 4 years of each other to achieve a criminal objective of the conspiracy.
I understand that part, and I'm not.
I haven't gotten past that part yet, too. I'm trying to figure out, how do I am at the point where, okay, that paragraph says everybody has to agree that they agreed to commit interrelated racketeering, a pattern of racketeering activity. But if they have to unanimously agree what pattern of racketeering activity was contemplated, then I need to at least tell them that.
Is there any disagreement among the parties that they do have to unanimously agree?
I don't think so. Everybody agrees about that, right?
You absolutely agree with what?
About what pattern of racketeering activity they agreed would be committed.
And state's view of this is that if it is, they had to agree to commit this act, that act, that act. I think we've passed that.
That's not what they're asking about.
And so when we
Hang on.
Sorry.
Does the state agree that there needs to be a unanimous determination as to what pattern of activity, racketeering activity, was contemplated as being carried out, whether it ever got carried out or not?
I don't believe the statute requires that.
I
And if I can just finish.
Yeah, I'm sorry.
The conspiracy has to contemplate the pattern.
Yes.
Yes, right. Does the conspiracy have to contemplate specific crimes?
I'm sorry, that's not what I mean.
I understand. I'm just,
Okay.
I'm trying to walk through the hierarchy. Does the conspiracy have to contemplate specific categories of crimes? No, all it has to do is contemplate that the crimes will be related to each other.
Right.
Because that's what would form a pattern.
Okay.
But do they have to be unanimous in their determination of whether they tell us what it was or not, of what that pattern was? I'm sorry this is probably really painful for everybody, but
and I don't
we
mean
need
to
get it
interrupt.
right.
I don't mean to interrupt anyone. I'm just looking at a case from the 10th Circuit, US v. Randall. I'll give you the site in just a moment, but I'm sure the state knows it. And I'm reading where they're trying to decide what circuits to align with. And they state further, we now join the circuits discussed above in concluding that for a charge of RICO conspiracy, and this is as the state says, a jury need only be unanimous. Well, they don't say this. A jury need only be unanimous as to the types of predicate racketeering acts that the defendant agreed to commit, not to the specific predicate acts themselves. And that's where I thought that we were in agreement with the state, that there needs to be unanimity. And I know you don't like the word types, and that's their language, not mine, Your Honor. But there needs to be unanimity, and let's call it the pattern of the predicate racketeering activity. And that's the 10th Circuit. And I believe they're agreeing with a number of other circuits.
Okay, so how about if we just say, would this work? Is this correct and sufficient? You must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be committed.
That's acceptable to Mr. Kendrick.
Could you say one more time?
Sure. You must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be permitted.
Committed.
What did I say?
Permitted.
Committed, sorry.
Your Honor, I do have a problem with that.
Okay.
Because I think the jury is going to read that as they had to agree to commit specific acts. I know that's not what you're intending to instruct them, but I'm afraid that's what they're going to hear, and that's what the argument we're going to get.
Then we
which
can
would be
say,
contrary to the law.
you do not have to be unanimous about specific acts, ... only, I mean, let's just nip
Unanimous.
it in the bud. Just tell them.
That would be great.
Only unanimous in the pattern.
That there would be a pattern.
Oh, we're so close.
And what the pattern is, really.
Right.
A specific pattern.
Yeah.
Well, the word specific just is another way to.
We
back
won't,
into
we
the
won't
same
say
problem.
specific, unanimous. I mean, I just said it, so I'm not going to say it again. You do not have to be unanimous about specific acts, as to specific acts, what?
You do not need to be unanimous as to any individual acts.
Individual, I worry about, because most people
As
think
to.
of individual, they think of a person.
Single act.
I like specific.
You do not need to be unanimous as to specific acts.
I think that's accurate.
Can you read it back as a whole,
Sure.
Your Honor?
You must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be committed. You do not have to be unanimous as to specific acts.
Are you going to say that after, if you unanimously determine that the defendant joined such a conspiracy, and then say what you said? I'm just going by the last paragraph, page 4.
I mean, yes, I don't even know where that language went, but what did I say? After the first paragraph, then what did I say? If you.
You mean, what did you previously have in this
Yes.
document? The document originally read, the one sent to us at lunch after that paragraph. If you unanimously determine that defendant joined a such conspiracy, comma, you must then determine which interrelated types, with the S in parenthesis, or acts of racketeering activity the defendant agreed would be committed.
No, I don't think I'm going to say that anymore. I think because I am saying the state has to prove they, agreed to join a conspiracy, understanding that somebody was going to commit at least 2 interrelated acts of racketeering activity. And within 4 years of each other, to either get or keep money or participate in the enterprise or to achieve a criminal objective of the conspiracy. I think maybe then right there, just put in parentheticals, quote, pattern of racketeering activity.
Did we lose your?
But then there was the language.
I know, I hadn't gotten to it yet. I'm sorry. Sorry. I think I would then just say you must be unanimous in your determination as to the pattern of activity the defendant agreed would be committed. You do not have to be unanimous as to specific acts.
So I'm not hearing if she's saying that they knowingly or unknowingly have to agree.
I don't know.
That's acceptable to Mr. Kendrick.
Okay.
Could we get a brief break at this point?
Yes.
Your Honor, obviously, I'd like to look at the
I
final
know,
words,
and
but
I'm
I
still
think,
thinking.
in principle, I think you've got it.
All right. Yeah, let's take a quick break.
Thank you.
She said it when mentioned the joining part. And Brittany, you were right. Within 4 years, 2 acts would be committed, and the defendant knowingly agrees to the commitment of those acts, of those crimes. I'm gonna run that last part back because it didn't make, I wasn't sure if she said knowingly or unknowingly, so I'm gonna just run it back real quick.
The final words, but I think, in principle.
Not that.
Us at lunch after that paragraph. If you unanimously determine that defendant joined a such conspiracy, comma, you must then determine which interrelated types with the S in parenthesis or acts of racketeering activity the defendant agreed would be committed.
Okay. No, I don't think I'm going to say that anymore. I think because I am saying the state has to prove they, agreed to join a conspiracy, understanding that somebody was going to commit at least 2 interrelated acts of racketeering activity. And within 4 years of each other, to either get or keep money or participate in the enterprise or to achieve a criminal objective of the conspiracy. I think maybe then right there, just put in parentheticals, quote, pattern of racketeering activity.
Did we lose your?
But then there was the language.
I know, I hadn't gotten to it yet. I'm sorry. Sorry. I think I would then just say you must be unanimous in your determination as to the pattern of activity the defendant agreed would be committed. You do not have to be unanimous as to specific acts. I don't know.
She lost me. She lost me. The DA look say, I know Joy behind. All right. We ain't seen much acknowledgement between the dudes though, for sure. Yak and Doug also on page did the right thing. Joy behind. Love should be in the courtroom taking lessons. Okay. Yeah. Let's hold prayer for the jury. Yeah, free the jury. I'm wearing my free the jury t-shirt tomorrow. Free the jury, because at this point, it's gonna take everything for them people to understand what they're trying to explain. I'm struggling to understand what she's trying to explain, but I can only laugh because this is crazy. And we are getting it in bite-sized pieces. This is going to be read to them in combination with a bunch of other instructions. And I'm just sitting here like, you have to unanimously agree on the pattern of racketeering activity. And then you have to pick 2 of the acts that have occurred within the past 4 years that may have been done in furtherance of the thing or the game in order to prove RICO, is how I'm hearing it. That's how I'm hearing it. And they were, at first they were saying that they had to unanimously agree on the pattern, on the conspiracy, and on the type of crime. But it sounds like the type of crime and the no longer matters. They just have to agree that there was a pattern, agree that people decided to participate, and then list basically 2 examples of participation. Like, that's how I'm hearing it. Like, how are y'all hearing it? Let me know what y'all getting out of it, because I could very well be wrong, but that's how I'm understanding what she said. I know there's a delay. But how do they have to agree? How do they have to agree on what? Yeah, this is bad. Do they have to agree on what to ask? Right. They have to first establish a pattern of racketeering. So basically, they have to agree that crimes were committed within the time period that they're talking about, within the 4 years that they're talking about, and decide if, the defendants were involved or not. If Yak and Shannon were involved in it, if they agreed to it, if they knowingly said, yep, I'm gonna, my little nail is lifting and I hate it. I'm gonna get that mug off tomorrow. So 1, agree on the racketeering activity, agree that crimes were committed. 2, agree that the defendants, Yak and Shannon, knew that they were going to be committed and agreed to them being committed, right? And then 3 basically are the overt acts, like what was done in furtherance of this crime that they conspired to commit. They will be stuck on the pattern. They will absolutely be stuck on the pattern because there were a lot of crimes committed. There were a lot of things happening. Yeah.
Don't wait for Black Friday. At Miller Furniture and Mattress, you get Black Friday savings and long-term.
I don't remember Yak and Shannon being around each other. In my opinion, they from 2 different eras, and I feel like when Yak came around, Yak was really about the music. I strongly believe the second set of folks are going to get toasted. Them boys, them second set of boys, baby, they gonna have to figure it out, because the way that they brought up Demikion Gorlington, Miles Farley, Nard, the way they brought their names up, trust and believe they gonna try to hang them boys. And the defendants failed to exit the conspiracy. What did you say before that, Ed? Because I know you said something good. You are correct, but the state has not carried the burden of proof of anyone leaving the conspiracy. And that's what he was saying. And the defendants failed to exit the conspiracy. Oh, at the end of the, okay, I see what you're saying. Let me see how did I miss? In the back seat, his friend goes to rob the guy leaving the gym. He pulls a gun. The guy happened to be an off-duty police officer whom had a weapon too. Not sure what she's talking about. She and a girl. Are they also stating that each defendant has to be a participant of those patterns and actions? Honestly, Ebony, that's the part that confuses me because it basically reads like anybody could agree to it. It's kind of how it was said, but then she also said that she was going to say the name. So that part confused me with honesty. That part confused the hell out of me. That's right. So how are they supposed to prove that? Or is it everybody else's crime included in that? Yeah, I asked them the same question. I'm hearing unanimous agree a pattern exists, but they don't have to agree on what the pattern consists of. Exactly. Well, exactly. The crimes could be, it could be any of the crimes, right? You could have robbed somebody, you could have murdered somebody, you could have stabbed somebody, you could have fought somebody if it was a battery or something like that. But they're saying that all of those things together create the pattern of racketeering, and that a crime was committed, and that you knowingly, agreed to participate in this, in this thing, and did not leave the conspiracy in no time. Let me not forget it. I think Yak gonna get off, but Shannon, I don't know. I don't know about Shannon either, y'all. I don't know. But here's the thing, though. The statute is written the way that we struggling, right? The statute is written so that it is, like everybody been saying, a catch-all. It's like there's always another way around of getting these guys in, and the way that they wrote the indictment, mistakes and all, still creates this safety net for them to say, well, Your Honor, these other people who are also in the gang, they have allegiance to this gang, they've got the same tattoos, they did X, Y, and Z too. And because this client has those same tattoos, then they are in agreement with whatever these other people did, and so they are guilty by association. Because I know you. It's just it's a slippery slope. Oh, okay. No worries, Sheena. I know y'all be talking too. It's a slippery slope. Like it's a slippery slope. Friends. No, Rain, they threw it out. They threw out the M charge on Quay. What counts did she decide on direct verdicts? So the only person who got directed verdicts was Yak, and he got it on charge 59, which was the violation of controlled substance at possession of codeine with intent to distribute. He got it on 60, which was the possession of cocaine. And then he also got it on I want to say 61 through 63, which were the weapons, the switches, the guns, they were all at Thug House. All at Thug House. Okay, Blake, I said that too. Like, it's double jeopardy. And let me tell y'all this, okay? Now, we talked about it a little bit earlier, how Doug did not present his alibi. He basically has not done that for the unaliving of Donovan Thomas, and he honestly doesn't really have to do it. But he didn't do it, right? With that being said, Doug still has to deliver a closing argument. And I think even though Doug can't, the judge is not going to allow him to say double jeopardy in his closing argument. It's not going to happen. So Doug is going to have to come up with a clever way to tell the jury, my client my client did whatever he did in the past. He's done the time for whatever he's did in the past. and he should not be held accountable for the same crime twice. He's gonna have to find a clever way to deliver that to the jury in order to get Yak off that second gang charge. I keep forgetting I'm not on TikTok. Yeah, I know on TikTok we can't say certain things. But Doug is gonna have to deliver a solid closing argument to try and get Yak out that gang charge. Because I do think that that's one of them that scares me. And I know Miss Tasha don't like me saying this, y'all. But if she see me, she'd be like, "Hey Taylor, keep faith, positive vibes only." That's what she tells me on TikTok all the time. "Hey Taylor, stay positive, Taylor." I know she's gonna be on my bumper if she hear me say this. But the gang charge on Yak worries me because of his conviction, because he's already pled guilty to it. And he's pled guilty to the overt act, which is now in the RICO. So it's like they can use that for count one, his conviction, and they can use that for the gang charge, whatever count that one is. So it scares me. I ain't gonna lie to you, because I want Yak to get off scot-free. It scares me. I just think that Doug is going to have to deliver a great argument. And I think that there's room for an argument to say, you know what? Yak and Duke, they were both signed with YSL. I got chips on my nails. They were both signed to YSL. They were both music artists. So, the argument could be made that he was just, going with his music mate, his label mate. You know what I'm saying? He was riding, sliding with his label mate. There's an argument to be made there to try and convince the jury not to convict Yak of that gang charge. I'm telling you. All right. As far as like the other stuff, Yak ain't been mentioned in nothing. So when it comes to RICO,
No.
Are we on page 4 you're on?
Yes.
Is there any way possible to throw that up on the monitor?
Yes, I could screen share. I could join Zoom and screen share.
That would be very good.
What a great idea. Okay. Bless you. I think I'm in Zoom already.
Thank you.
I'm not usually the one sharing, so. Moment, I've got it. I just have got a lot of things open, so I think it's this one. Is that the right one? Okay.
Oh, that's very helpful. Thank you.
We should have maybe been doing that the whole time. All right. So one thing I've thought about is just kind of lead in, hey, y'all, your verdict as to every count needs to be unanimous. That means you need to be unanimous in your determination that the state has proven every element of that count beyond a reasonable doubt. For count one, here's what the state has to prove. And I've put all of it in there. And I don't know whether we want to say to achieve a criminal objective or the one or the other. We can decide. But I'm going to say all of it. They have to prove all of this, and then they also have to prove, an overt act. To be unanimous on this count, you must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. You do not have to be unanimous as to specific acts. You must also be unanimous as to any overt act or acts committed to further a criminal objective of the conspiracy. And then whether we want, again, the reminder that it has to be after May 10th, whatever. And then as long as they're unanimous on an overt act, do they have to list the overt act? Or do I just, it's kind of the same question again.
State's positions do not. They do need to be unanimous. There was one, and which one it was, but they don't have to list it They only have to be unanimous as to one.
Your Honor,
Yes.
for the record, I am objecting to that you do not have to be unanimous as to specific acts.
Okay.
However, having said
The day you get your Nuvia 24-hour permanent teeth is the day that you reintroduce yourself.
the last sentence that Mr. Floyd is objecting to
Uh-huh.
doesn't make a lot of sense, because we're telling them they don't have to be unanimous, and then we're telling them you should note on the verdict form.
That's what I'm asking. Do they still have to?
Right. If we're going to keep in that that you do not have to be unanimous as specific acts,
It's confusing
as a juror, it wouldn't make much
to
sense.
then say you have to unanimous about an overt act.
Those are different acts. One is
I know, but are they going to know the difference? Acts of racketeering activity. Maybe that's the way to clear that up.
Okay.
Would that work better?
I think it would.
Okay.
and then I understand the state does not want the overt act on the verdict form. The defense would want or at least Mr. Kendrick would want that on the verdict form.
I would.
Which one it is?
The one that says you should note on your verdict form any overt acts in furtherance of the criminal conspiracy to which all 12 of you unanimously agree. I would like to see that on the verdict form just to ensure that they did pick one within the proper time frame.
Okay.
I'm not sure how council contemplate that this would actually happen. They list a number or
They'd write out, I don't know. I mean, I guess if it was an act in the listed out, they could just list the overt act number.
and I think this is why I'm asking, Your Honor, because they could also find an overt act that isn't listed out.
Well, then we'll give them a little blank for that.
I mean, I'm serious, like literally
So am
just
I.
say, and do you find, you can list them by number, or you can list an act, anything else that you determine is an overt act. And you can go ahead and do that. I'm trying to think of physically how this happens without them. And I'm not, to be clear, I'm not saying the state doesn't object to that. I'm just trying to figure out what it is we're talking about before I address it.
How about that?
And Your Honor, if you could scroll up toward that long paragraph in the middle of page 4 there where it says for count 1. I think that's as concise as you can possibly make it, but I'm wondering, given that it's such a complicated paragraph, if it might benefit just from a formatting perspective if you broke it up the same way you did on page 1 where the different elements are on different lines.
For one thing, we need to decide, is it going to be, are we going to say this? Or are we going to say, well, that did not help at all. Which of those two things are we going to say? There. So the orange is what Mr. Floyd had proposed. The blue is what I had originally. And we could have the i.e. a pattern of racketeering activity. That actually doesn't go there. That goes up there. Oh, no, it doesn't, because it has to be to achieve a criminal objective of the conspiracy.
I agree with that. I think the get or keep money or other property and participating enterprise is wrapped up in the statement of the criminal objective, which you've given them before.
Yeah, I know you think that. So thank you. What does the defense think? And actually, Mr. Floyd, do you think that this survives appellate review as giving them the correct instruction?
Yeah, I may be right, I may be wrong, but that question is forefront in my mind in everything I'm saying.
Okay.
Yeah. And in part of that is the appellate analysis, which is and this is why I've been referencing where you've said things in other places that you know better than I do, the jury instructions are read as a whole. And
I know
that encompass, given what these instructions have elsewhere, that gives me a good deal of comfort.
Your Honor,
Mm-hmm.
my preference is more for the original language with the caveat that might actually go against me is that I'm just not entirely clear what participate in the enterprise means.
Yeah, me either, but that's the way the statute's written.
Um,
I mean, honestly, I think it's Mr. Floyd's might be more elegant, but the original tracks the statute, and we're less likely to commit error by tracking the language of the statute. Because if you go way up above to what the elements are, one of the elements for Part B is participate in the enterprise through a pattern of racketeering activity.
Right. Yeah. Obviously, I can't challenge that, Your Honor. I was looking at in the language that I was suggesting, I was looking at number 7, we list the elements, which references the criminal objective. So circling back to that, I'm trying to be consistent in the language.
I mean, the other way we could say it would to join a conspiracy, understanding that, no, it's just too awkward. I'm trying to flip like the order of them, that they would get or keep money or participate in the enterprise through, but I'm not going to do it that way. All right, it's just going to stay like that.
and then drop a comma after the 2017.
Yeah, you know, we're just going to have to agree to disagree on that, because I'm sorry, but I don't like to offset the year with 2 commas. Sorry.
Do you use an Oxford comma?
Oh, absolutely.
Okay, well, we can agree on that.
Okay, yeah. All right, and so then they're being told they have to be unanimous about the pattern of racketeering activity, but not specific acts of racketeering activity. They need to be unanimous that at least one overt act was committed in that time frame. And then they're going to list on the verdict form whatever acts they unanimously find. And then probably when we get to the verdict form, which we need to do soon, it's going to be, you can list them out by act number or write out what you find.
I understand, for the record, we do object to that last sentence.
Mhm.
I don't think it's necessary. I understand that you disagree with me. And I'm just quoting that.
I don't know if it's necessary, but it's not error to do it. Is it? Okay.
That language itself, I'm not certain that it's error, Your Honor. The question is really, this is one of those devil in the details things, which is going to be exactly what that verdict form says when you embody that language.
Well, I've invited people to submit proposed verdict forms. So now that we know what the charge is going to be, I would continue to welcome that.
I understand, and we will modify our proposed verdict form because now we have a better idea of what the charge is going to be. Thank you.
And I'm sorry, it's just not an easy thing to do. Okay, so I shall stop screen sharing for now. All right, we need to circle back to a couple of items that were on the
For award-winning service and top reviews, you can't beat Seeger Toyota.
Save $7,300 on Tundra or
And I don't mind if it would be helpful to share this one as well. Was that helpful?
Very helpful. Thank you.
Is it the version that was sent last night? It should be,
Yes, I haven't done anything to it. So I'm just going to scroll through unless anybody's thought of anything else to where we had noted we needed to. All right, the stipulations.
We're working on that as we speak.
Back up to the beginning and take out the counts on which a directed verdict was granted, which were counts 59, I don't know how to do that one. Laura, can you take that for action? Because I don't know how to get rid of the. Thank you. 59, 60, and 62 are out.
Yes, you're right.
And then
That's changing on. Well, figures, is it?
63 is not gone completely. It's just different now.
Now it's a 131 instead of a 133,
Right.
correct?
Maybe we take off the language. He was convicted of a felony and just say possession of a firearm by a convicted felon.
Right. Right. Just ditch the previously convicted of a felony part. It would just be possession of a firearm by a convicted felon, 131. And we'll just have to explain to them something. I don't know what. All right. So then from Mr. Stillwell, 52 and 64 change. All right. Y'all are still working on the stipulations. And the stipulations, once you write them up, they can just go out with the jury? Or is that what they're going to do? I mean, in which case, if they're going out, I can just kind of generally say about these topics instead of reading them, or I can read them, whichever. So, I mean, normally it's like a piece of paper that's, joint exhibit, whatever it is. I don't know if y'all have done any more joint exhibits, but.
So maybe we just make reference to the joint exhibit numbers.
Yeah. Okay. Have entered into, the parties have entered into stipulation about certain facts. And then.
I think there's 4 separate stipulations. So I don't know if we're going to make each number.
These.
Is that correct? 4?
Bad typing, but we can fix that later. These 4 stipulations are marked as joint exhibits. We can make it pretty later. Okay. Oh. Really bad typing. Maybe I shouldn't type while it's on the screen. And then where the parties stipulate it's in the nature of evidence. All right. Apparently down on 13140, there was a question as to whether you were going to check, Ms. Hilton, on whether any of the criminal convictions were for a crime of dishonesty or making a false statement. Okay, well, at this point, we're just going to say felony.
Yeah, they're not sure.
Okay. I don't know why this is highlighted.
Because I objected to it, but it's pattern, so I understand.
I've got a question. I mean, yes, a conspirator is an accomplice, but do we need to use both of those words here when we're saying where the witness is an accomplice? It wouldn't hurt to say or co-conspirator. Thoughts, anyone? You don't care? I mean, I guess we're going to tell them, here's how you can, okay, I'll just leave it the way it is if nobody has any preference.
Actually, I'm sorry, Your Honor. I think it's a good idea to put or co-conspirator in there. Just to prevent confusion as to about accomplice.
Anybody care whether we say on its own or by itself?
No.
We'll just go back, and I'm not going to do this right now, but we'll just say or co-conspirator for all of those. So I'll just highlight that. And we'll go back and do that. All right.
Your Honor?
Mm-hmm.
I could be mistaken, but the only concern with the accomplice or
Mhm.
co-conspirator is that that corroboration of an accomplice instruction with it, if it's truly a co-conspirator, it's not
You're
that same
right.
legal principle,
You're right.
I assume, thank you, Your Honor.
All right. And we're instructing them separately about. Sorry. All right, and the defendants have both chosen not to testify, so we now know that. Any ideas? Coming back to here, y'all.
That's what I'm trying to figure out. I think on the one above, we were trying to determine if that was appropriate, because did we really have a photo lineup type scenario where that would apply? I don't. And I think we were adding accomplices to the one below because we were trying to think through, there were no photo lineups type scenarios involving Mr. Kendrick.
Yeah, there's no eyewitness identification really of either of these defendants.
However, there was to certain overt acts that were not these gentlemen, specifically Mr. Demise McMullen, Mr. Walter Murphy, a shooting case.
Right.
I remember that. There's probably
Okay.
So we were trying to figure out how, if you look at 135.
Well, and it's not even just lineups. I mean, it's like the girl who was in the car that identified Ryan as the one who killed.
And so I think that probably needs to stay in there. So I think in 135.11, what we were struggling with is it's written.
Yeah.
Defendants.
Yeah. Right. So.
I don't love the conspirator because it's almost, I know it's not intended this way, but it's almost like a suggestion that Ryan is a conspirator with us or Walter Murphy is a conspirator. Can we just say individual? Identify an individual?
At CarQuest Auto Parts stores, we do whatever it takes for our customers.
If it's not in regards to a defendant, the beyond a reasonable doubt, like the germane issue of this is, how a jury's going to
Right.
pretty
Yep.
significant identification of the
Yeah.
defendant in a crime.
Well, except that when we're dealing with the overt acts, even with Mr. Ryan, I mean, the overt acts still have to be proven beyond a reasonable doubt. So I don't think the standard is any different.
Now, this, I have no idea as the perpetrator of, I mean, it's not necessarily crimes that anybody's charged with if they're overt acts. As having committed.
The perpetrator of the act?
Yes.
And then not the party, right? Party. The perpetrator of or party to the act.
Or act/crime. Whatever.
Well, act is all.
Ugh. The act/crime? The act. Do y'all want this part at all?
Yes, please. We have not-
That a defendant show
That the individual.
that another person committed any alleged offense. This part's weird because of our overt acts.
If another person committed the alleged act. Perpetrated the alleged act.
That okay with the state? Just change offense to act?
Yes, Your Honor.
Okay. And then I guess we're fine with that. I mean, if we're going to say this part, I mean, I don't know that we need to say this part at all right now.
Or maybe prove identity. The problem is, these are written for the quote-unquote offendant.
Yeah.
but Theoretically, we are, myself and Mr. Weinstein and our clients are potentially defending not only our clients, but other individuals as
Right.
well. But the burden of proof doesn't rest with us, so
Right.
it rests with the state. So I think that's an appropriate, I would just, maybe instead of, I would just go back to the more inclusive individual. Or
But they don't have to prove a specific individual. I mean, they could prove some unindicted co-conspirator committed one of the overt acts. And so by definition, we might not know who they are. I mean, it says up here beyond a reasonable doubt. I think that's really all we need to, it's not necessary that the defendant show that another person committed the alleged act. I think the rest of this, because it's written for something that's totally not applicable here, maybe just is confusing and also not necessary. What do you think?
The state agrees that the remaining two paragraphs are not needed, Your Honor, for the purposes just outlined by the court.
But it seems that the last paragraph would apply when we're speaking about indicted or unindicted co-conspirators, but we have to change the language. Actually, I don't know what to do with that.
I do.
Could we add on the end of that paragraph that remains, like the burden of proving
The burden never
identification,
shifts to the defense.
or the burden of proving identification? The state bears the burden of proof for it.
What?
That's what you do in the last paragraph.
The state has the burden or bears the burden of proving identification beyond a reasonable doubt. Well, we already had the beyond a reasonable doubt, but bears the burden of proving identification.
Is that in the beyond
No.
reasonable doubt?
How about just the burden of proof never shifts to the defense?
That sounds fine. State agrees, Your Honor.
All right. All right, I'm going to give that, so we're going to unhighlight that. Knowledge. So some of these come out. Yeah. I'm going to say a firearm here. Okay. Yeah, but they only have to.
Yes. Your Honor, before we get to the only thought with the knowledge piece, of course, the court outlines the crimes provided. The state just wanted to make sure and was thinking, out of an abundance of caution for the jury to understand that, RICO is not what, this paragraph is envisioning in terms of that knowledge requirement. I mean, the court or the state was thinking through out loud if, this specific provision or instruction, of knowledge doesn't fit the RICO instructions are kind of in their own universe.
Well, that's why it doesn't, I'm sorry. But you give a set list.
Yes, Your Honor, or this instruction is limited to these, counts or.
It sufficiently says this doesn't include RICO.
Thank you, Your Honor.
Okay. Appreciate you bringing that up. Okay. All right, I'm saying this before the RICO also, but I don't think it hurts to say this one. Is this multiple ways of committing a crime only applicable to RICO?
No, Your Honor. I think when
All right, Laura, do you want to just delete all of the RICO stuff and drop what we just did into there?
Your Honor, in answer to your question about more than one way,
Mhm.
that there are gang act charges here which allege more than
Okay.
one type of criminal street gang activity in as the, I hate to use the term, the predicate or foundation for the criminal street gang violation. So we
Okay.
have that issue there too.
All right, so I'll just kind of say that in here in the midst of it, and then I'll say it again before I'm talking about RICO. Okay, criminal gang activity. Counts 50 and 57. This one may have to be separated out for each defendant. If we're if we're listing crimes.
Well, we could put, I'm not.
Or we could
without
put-
looking at the statute, I don't know the term of art, but I think it's criminal gang activities. And
Yeah.
and then I think we.
Consumer Reports has just named the Subaru Crosstrek a top pick, an honor given to only 10 vehicles in the
Would constitute improvement, would constitute criminal gang activity.
I have no idea where that,
But count 57 is pretty specific as to what are the actions.
I can't. What was somebody saying?
Well, you had the blank and it looked like you were looking, I was interpreting that as you were gonna add a specific offense. And I was thinking you would just put criminal gang activity as defined.
I mean,
And then we define criminal gang. It's defined, I think, above, but
It's not. Oh, yeah.
Your Honor, in that
Yeah.
paragraph where it has criminal gang activity, I believe there needs to be possession of either marijuana with intent to distribute, because it has any criminal offense that involves violence, possession of a weapon, or use of a weapon. So
Yeah.
there needs to be a comma, possession of marijuana with intent to distribute, because that's not defined in the first criminal gang activity. But it is
We don't have use of a weapon alleged, right? Oh, yes, we do. Never mind. Never mind.
You have it defined below, but not in the first criminal gang activity paragraph.
So possession of marijuana,
With intent to distribute.
does it have to be with? Okay.
That's the only charge left.
Does that capture all of it?
Yes, Your Honor.
So I think. Why is that
But
not-
don't, I'm trying to understand, Your Honors, down here below where you have 50 and 57 lumped together.
Because that's subsection A. Subsection B, as a leader, or no, I'm sorry, to maintain or increase his status or position, which your client is not charged with.
No, but here's what I'm trying to understand, and I need the court's help. In the indictment for count 57, if you look at that
Yes.
count, and again, I'm not really arguing, I'm just kind of hoping for some enlightenment.
Okay.
The street gang activity under A is, the offenses are specifically listed: possession of marijuana with intent to distribute, and then the codeine and the cocaine, which have been thrown out,
Right.
and then possession of firearm during commission of felony. So shouldn't, for a conviction under 57, one of those two things need to be found?
Yes, which is what the blanks would be.
Yeah, but that would apply to 57. Isn't it different for Mr. Stillwell in 51?
Yes. Yes.
Oh, I'm sorry. Okay. I
It's
understand
okay.
now.
I mean, so it may be that,
Or 50, I guess.
it may be that right here, we just say criminal street gang or whatever it is, criminal gang activity. And then below, what typically happens then would be, can somebody look up never mind, I've got it right in front of me. No, it's 5.3 that lists what the gang activity is, right? Yes, Mr. Sharp.
So I would suggest we just put in criminal gang activity, and then we have the definition of criminal street gang, and below that, because we're just kind of going, I'm thinking sequentially by the elements. Below that, we define what you're about to talk about right now, criminal gang activity, and then we bring that paragraph that was just above all these elements, drop it down to there.
So you're saying move the criminal gang activity paragraph down?
Down, because it's like we're giving the definition before we give the elements. So we give the
Okay.
elements, and then we follow with the definitions.
Where in 1615.3 is anything about drugs? Is it just because it would also be an offense of racketeering activity?
Yes.
Okay. All right. Okay, so these would both say criminal gang activity, right? This is so painful. Oh, where's paste? And then take this and move it down below. Is that what you're saying? That makes so much more sense. Thank you. Well, I guess we'll do criminal street gang and then we'll do criminal gang activity. Right. What?
I have a feeling, as we scroll down, we have criminal gang activity. Right, so we kind of say the same thing twice.
What are we doing?
Right where your cursor is, well.
Yes.
Above malice murder, there's two paragraphs that right now are redundant.
This second paragraph begins to delete as charged in this page.
This?
That and the paragraph above it both say the same thing in different ways.
Criminal gang activity means we don't have conspiracy to commit, right? Yes, we do. Sorry. Well, that's the definition, right? So what are y'all saying?
You're saying as charged in this case, and we kind of.
So, I mean, I think it needs, I don't think we need that, but murder, possession of marijuana, we don't have these anymore.
Okay. Your Honor,
Yes.
may I sit so I can see my screen? In count 57.
Yes.
And again, maybe I'm just not understanding this. Maybe I'm just tired. In count 57, the criminal street gang activity is alleged to be based on the commission of one of
Possession of marijuana with intent to distribute and possession of a firearm.
right. So, but not murder.
Right, but
You have murder, but the problem is the way that it's worded with 50,
which is why we may need to separate this
with
one out.
57. That's what I'm trying to say is murder is not included in 57 gang activity.
I understand.
Okay,
But
thank
it's
you.
not going to be, they will have the language of each count when they do guilty or not guilty. And so when they get to count 57, the gang activity alleged against your client is not going to list murder. It's just going to list possession of marijuana with intent to distribute and possession of a firearm as alleged in certain counts.
Okay.
Okay.
As long as it's clear in that form,
Okay.
then I'll be okay with that, Your Honor.
58. Okay. So we're now we don't have to define this non-pattern charge because they're not being charged with it. Nor do we have to do possession of a machine gun. We do have to do possession of a firearm. 131 though. That is a pattern, right?
Well, Your Honor, machine gun is an overt act. So if we're
Okay, well, why don't you just give me that again when you send all of the overt act things? Because I may actually. Okay, well, it's already in this or somewhere else? Right, but is it dropped into here anywhere yet? Okay, all right. Okay, we just need to pull the pattern for 131 then and put it in whatever that document is that Mr. Atkins sent. Okay, so.
Whatever you do it for less at Harbor Freight.
Say, oh. It's just any felony, right? If it's 131? Okay. We might need to look at that whole thing again to make sure it's correct, but. All right. So possession of a machine gun. Laura, can you just lift that and put it in with the rest of those overt act explanations? Thank you. Possession of marijuana. We don't have that, right?
correct. Well, that'll be.
We have it possession with intent to distribute, right?
The marijuana, we do have that for the overt act.
Okay, well, that will need to go in where the overt acts are explained. So did y'all send that separately? Laura, will you just make sure that one gets grabbed also? We only have marijuana, right? No controlled substances now? I guess we'll still need this for some of the charges that exist, because, right? Yes.
Although, Your Honor.
Yeah.
Could you scroll up?
Mm-hmm. More?
Well, if it's the over, I don't, in, on behalf of Mr. Kennedy, the state must prove the defendant possessed.
Oh, right, right.
The code, the code you need case. Thank you.
Good eye.
And there it is again in the next paragraph.
I'll see now you're taking credit.
I'm going to do a wordsmith.
Yep. It's everywhere. Okay.
In the sentence above, Your Honor, if you go back up to equal access, the second line.
Thanks. Okay. We still haven't gotten the verdict form, but mm-hmm.
The state gets into.
Oh, I'm sorry. Yes, I know. I mean, we haven't settled on one yet, nor have we reached a point of discussing beyond what we've, yeah. No, yeah.
And I would really like some time to, I understand that you gave us a heads up on the verdict form, but I'm still going to need time to weigh in on that.
All right, so I think that's everything for this one, other than making sure of that. But now we need to go through, is everything patterned for the other crimes that are only other acts? No? Okay. Why don't we get out of this? And do you want this forwarded again to you so everybody can take a look at things that we might have missed?
Sure. Could we say it under a different title?
I mean, I guess we could do that. Yeah.
I didn't mean that sarcastically.
I know.
Your Honor, this is probably, of course, but the RICO that we worked on as well, instructions.
It's embedded.
Okay.
Yeah, it is in there now. Thanks. Okay. Let's see. All right, Laura, I'm just going to let you, are you going to be the one to share the,
I can, but I.
which would be easier? Okay. Let's everybody take a minute. What's the date? November what? Thank you. So I'm going to title this November 20th, the jury charges with RICO, and then Laura, you can send it. Whenever. They don't need that right now.
Well, we'll have to add all this in as well.
Okay. All right. And
I'm sharing this now.
okay.
So this is what the state sent over earlier. Obviously, I took the title off of it.
All right. So what's on the screen now is everything that would cover anything that's a crime in the overt acts.
Except for maybe you can add again based on
Okay.
other things, but.
What is this called? Is this jury charges thing? What is it called? Okay. a good title?
So, okay. Mr. Weinstein just brought up a point to me.
Okay.
With these overt acts, the pattern charges refer to people as defendants.
Mm.
And I don't.
Yes, no, we definitely don't want to say that. So maybe we can just do a global replace of someone,
How
a
about-
conspirator.
How about actor?
Person. I definitely.
Person?
A conspirator.
The
I think
person.
would be
I don't want.
comment on-
I mean, okay, but maybe the person assaulted another person,
Or
the
Actor.
other person, the
Actor.
person, that's just going to get confusing.
Actor.
Perpetrator? Perpetrator. Okay, so do you know how to do a global replace? Okay.
or maybe
Alleged
alleged
perpetrator.
perpetrator, yes.
All right, so we'll change defendant everywhere in there to alleged perpetrator. And then,
Can I ask why conspirator is not appropriate? Because you have to be either an indicted or unindicted conspirator to make everyone guilty. You can't just be some.
a conspirator, maybe?
Yeah.
And alleged,
Alleged conspirator.
well, no, because they'd have to actually be a conspirator.
Right, but I'm concerned if Your Honor gives jury instructions saying the conspirator, that is not intentionally, but.
No,
it's
but
a
might
kind
be
of-
saying, hey, they are conspirators, and we don't want to do that. That's for them to decide. Okay, so the perpetrator.
Alleged perpetrator.
The alleged perpetrator, sorry. All right. All right, so there are two non-pattern charges. Criminal use of an article with an altered identification mark. Can y'all see that on the? I'm not the screen sharer right now, and Ms. Pursfield's doing like 7 things at once.
There you go. That's where
Thank
we're
you.
at. I'll finish the rest.
Okay. So what are they alleged to have done, whoever had this? I mean, we want to get rid of the language that's not applicable, so
It's just concealed.
conceals. When he conceals,
And it's Act 53, Your Honor, in the indictment,
thanks.
which Trontavia Stevens, and then it goes on, criminal use of an article with altered ID by possessing a firearm from which the accused knew the identification mark had been removed for the purpose of concealing and destroying the identity of said article.
Oh, okay, so it's a person commits the offense of whatever that is when he possesses, right? A firearm.
Yes, Your Honor.
I'm sorry, say that one more time.
Okay, so when he, and then get rid of from or all the way through possession, and then change it to possesses a firearm. Yeah, which he knows. All right, and then that's it. Then I think it's fine.
You can take out nameplate and serial number, right?
We can, yeah. The manufacturers, what was alleged?
Serial number.
serial number.
Yeah, we can try.
Or are there distinguishing?
And it said,
What it alleges is the identification mark,
correct, Your Honor.
which did y'all mean that to be the serial number?
I believe, Your Honor.
I think it's fine the way it is. Okay, and then implied, what is this? Why do we have that? Where did that come from? Number 10.
I include that in all my murder cases. McBurney gets it all the time.
Is that not in our,
Abandoned and malignant heart isn't defined. It's from, obviously, it's a non-pattern charge, so I get.
I think we have malice in here, and we say malice can be, it is such, I'm paraphrasing, malice can be formed within an instant or something to that effect in a pattern. I think this is unnecessary because we've already discussed malice in the pattern.
The pattern just doesn't define what an abandoned and malignant heart is. It says an abandoned malignant heart may be inferred from the circumstances.
Why do we need to?
hang on. Hang on, y'all. Let me get to the patterns. So it's,
For the reason that Mr. Bacchus said.
for malice murder. Because the pattern says you may also find it when all the circumstances of the killing show an abandoned and malignant heart, which nobody knows what means, even though there have been case after case after case about what it means.
And maybe we don't need the first.
So,
We just need the abandoned and malignant heart sentence.
So, yeah, part of it's covered. We say you may also find malice where there does not appear to be significant provocation in all the circumstances of the killing show an abandoned and malignant heart. So that first sentence is already covered. Oh, and the second, well, sort of the second sentence. So basically you're looking for a definition of abandoned and malignant heart.
Yeah, the first sentence I just put in there.
Okay.
Where it could be put in the pattern chart.
Is there any definition in the like bench notes of the pattern that define it? All right, I'm not going to do that. Delete that one. Is that everything? Those are all of the charges that are in the,
I just added possession of machine gun.
okay, well, all right.
It's out of the other set, but we'll go figure out how we're gonna do that.
Possession, oh.
I mean, I guess you're going to need to add the codeine and the
That's a machine gun.
cocaine back in if it's not there.
Wait, that's, they don't have to have possessed a machine gun during other crimes. They just have to have possessed a machine gun, and then we need to define what a machine gun is. I think we lifted the wrong one.
That's what we have in there.
Okay, well, we need to work on this one. That a perpetrator possessed a machine gun. A machine gun is any, yes, period. Yeah. I think that covers it. Right?
And then, I don't know what happens with codeine one, but we'll get that. So
131, I don't know.
codeine and cocaine. Is there anything else?
We might need theft.
Theft.
Theft by receiving stolen property, if you ever shoot gun, theft by receiving stolen gun.
Those are overt acts that aren't, okay. Well, can you quickly grab the pattern for that? Is it theft by receiving stolen property?
Yes.
All right. Is that a separate?
Can we go back? Can we go back to the machine gun when you get a moment, Your Honor?
Okay, yes. Theft by receiving stolen property is 2.64.80, which Laura, I can grab and drop in here, but will it show up on?
It should.
Okay. I'll just put it.
Wix gives you the power of AI to build the website you need. With full business.
Oh, well, you'd have to move it to that part. I put it right above possession of a machine gun. Is it there? Yeah. Okay.
Okay.
And obviously we'll need to change defendant again, but.
Can we go back to what you removed in machine gun when you have a moment, Your Honor?
I'm not the one moving it.
Oh, okay.
So yes, but we have to be patient with Ms. Persever.
I believe you removed language about commission of a crime. That's in the statute, and it's also the way.
On machine gun?
Yeah, it is. It's A1. It shall be
What's
on.
the statute?
It is 1611-160.
Thank you. I've also never done a possession of a machine gun trial.
Well, there you go.
1611-150. Okay. 160.
On the machine gun. I will as soon as we get there. I have to get this added back in.
Oh, how interesting.
Yeah.
How odd.
I don't know why that is, but I'm not going to question the wisdom of our legislature today.
Okay, so it shall be unlawful for any person to possess a machine gun during, okay, so I guess we'll go back and lift them back.
And then in the count, there's a specific list of the offenses.
So it's only alleged that so that would be the two that are left, the possession during the commission of possession of marijuana with intent. Are other people charged with possession of a machine gun?
Yeah, there are. And so there's a list in 62, which probably should be included here, which is criminal street gang activity, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine. I could read those off, Ms. Percival, if you'd
Well,
like. Okay.
as it's indicted, it's participation, it's everything that's in 62. Is that what you just said? Okay.
Yes, everything in 62,
All
Your
right,
Honor.
so we can lift that from
Okay.
the indictment.
Thank you.
Or Laura can just type it right now. Okay, what else?
We'll need to add back in, Your Honor, possession of methamphetamine with intent to distribute, hydrocodone with intent to distribute.
Hang on just a second. Why are we adding those back in?
Because those are Act 69 and Act 70, they're overt.
Overt acts. So are there overt acts that are possession of a machine gun?
Yes, that is.
And those are 69 and 70?
No, I'm sorry. Possession of machine gun is 188.
So they were alleged to, Kitchens and Williams were alleged to have possessed meth and hydrocodone with intent to distribute at the time that that raid occurred?
No, sorry, two separate conversations, so I should finish.
Okay. So the machine gun one is fine now.
Yes.
And you're saying separately as offenses that we explain, got you, we need to do possession of meth and possession of hydrocodone with intent to distribute.
And possession of MDMA, which is Act 77.
Okay.
Hang on, real quick. Which ones are intent to distribute and which ones are possession?
All of those are intent to distribute.
Methamphetamine, hydrocodone, and MDMA.
Those are all intent to distribute?
Yes.
Okay. And is there, other than the cocaine, is there anything that's just possession?
Do we,
No,
do we still have a possession, a simple possession of marijuana as an overt act?
I believe we do.
I don't know, and I know we're all speaking at once, but I don't know if you would need to do MDMA because it's Act 77, and it's just referencing what Mr. Nichols had been previously convicted of to make him guilty of possession of a firearm by a convicted felon.
So we don't need that. Thank you.
Thank you.
So it's MDMA, no.
And the hydrocodone, no.
No, we need hydrocodone.
We do?
Yes.
We do, that's.
Oh, sorry. Okay.
Act 70.
Sorry.
And if we don't, I think we added it back, but possession of codeine with intent to distribute.
Yeah.
Yes. I'll try to go back to a double check.
Your Honor, I'm double checking. I'm just control Fing possession and indictment to make sure I'm not missing
Okay.
anything. And there is Act 49 has possession, simple possession of oxycodone.
Okay, so on the possession, do you want them listed separately? I guess so, yeah.
All right, I think we're getting to the end, but I need a quick break because I didn't take one when y'all all did earlier. So I'll be back in a sec. Y'all can take a break too.
Thank you.
Right. Yeah, I know I missed the last hour. I'm so sorry, but I'm happy that you all stayed in here, kept the chat going, and chose to keep the conversation flowing. So thank you. I appreciate that. That's how I know y'all real Taylor gang in here. Y'all real Taylor gang in here. So that's what's up. What I did catch was pretty interesting. So they changed defendants to alleged perpetrators. And then I also heard Doug come with the case law on that machine gun. I'm gonna have to go back and watch it. Now I'm gonna have to go back and watch it. But y'all gotta catch me up. What did I miss? Because once I started listening again, I say, wait a minute. Y'all still bringing in the rug charges, and I knew they would bring them in because they want them there to support the overt act. But baby, they want them there to support the RICO. But baby, y'all sitting here. I think that's gonna be confusing for the jury. Y'all sitting here trying to catch these boys up any kind of way. It don't matter how y'all get them. Y'all want to get them. Oh, thank you. A bunch of bull. You don't know? All right, somebody got to come up and give me a rundown. Where my boy Ed is? Ed not in here no more. Ed. Y'all know Ed is Taylor gang now. We gonna adopt Ed. Mr. Fobbs, you Taylor gang now, okay? You Taylor gang now. I need you to come catch me up. Ed was here. He was here. Okay, and Paige allowing it. Okay, somebody got to come up and catch me up. I left, came back, and still confused. Here's the thing, though. We're gonna hear her read this out loud tomorrow, right? We're going to hear this tomorrow. I think what I'm going to do is I want to make some content around, I don't think it may not be in here anymore. I think I want to make some content around the jury instructions and post it on YouTube to go over with the people. Shout out to Antonio because he was the one who suggested I make a jury instruction video. But whenever we actually get the jury instructions, I think I'm gonna break that. I'm gonna try to break that down. I might need some help. Okay, here's the deal. All right, what's going on? Tell me what I missed. I feel like if we're all sitting here discussing it with them and we're stressed and confused, once it goes to the jury, it's really going to be an issue. You might be on some. You might be on to some. Okay, Ed. So I posted the link. So if you want, if you can come up on the stage with me real quick and break it down for me, or you can write it in the chat. We'll wait for you. Whichever one you want to do. If it's easier to speak, just come up here and speak. If not, if you can't, it's all right. We'll read your comments. My head hurt. Everybody say they head hurting. I hope the jury don't get irritated. 333. Peace and prosperity, everybody. Okay, Jessica, I didn't know you was out here in the Central Time Zone with the people, aka me, because I am definitely Central Time Zone. Nothing but a bunch of siding and talking about the going for position. Am I gonna have to run it back for an hour? Yeah, just for until the break over. I think it would be the opposite. Okay, Ed might be a little bit behind, y'all. We got to give him a little grace to catch up with the people. Y'all, we waiting on our boy Ed to come up. He got to catch me up on the last hour. I didn't miss the whole hour. Okay, I was trying to see both sides, but I can't find anyone on YouTube that's backing the prosecution side.
Hi, my friend Taylor.
Okay, Ed is in the building. What's going on?
I got a toothache, but let me tell you this. This is what's going on. They ain't bit more got a RICO than a man in the moon. Let me tell you something, man. Let me tell you fact. Let me tell you fact. The fact is, you got somebody that don't even know who shot out of a car. That's the first thing. You got people speculating.
You with us? Ah, man, Ed, we can't hear you no more.
I think you got. And I'm gonna say this. Man. Y'all need to stop that bull crap going on. That's bull crap. All of it is bull crap. It's that hooked up railroad stuff. You can't hear me? Hold on. You got a delay in your system, baby. You got a delay in your system. I got a 27 Max, so you got a delay somewhere.
Yeah, it's a lag.
Okay. Well, look, here's the deal. What they really trying to do on the snake side is force a plea. That's what they want. They want a plea. Listen. How would you put how would you put but they want a murder plea. They want a murder plea. That's what they want. They want a murder plea. You got to remember, look at y'all DA. Look back. They dropped the charges on Trump and his cohorts. The Georgia Superior Court. Think about it, y'all. They got $7 million missing. It's missing. And it's not accounted for. Nathan Wade, Stanley Willis. So it's imperative. It's mandatory. She's scaring the shit out the DA, excuse the cursing. But she's scaring the shit out them DAs. Y'all better come back here and quit something. Y'all better come back in here with something.
Yeah, I think something going on with the audio, but y'all, it's on to something. He most definitely on to something because they didn't spend all this money, all these millions of dollars is gone, and now they want to be able to confiscate all the thug stuff, like y'all saying in the chat, and they need to get a conviction. And it's my personal opinion that the reason why they didn't drop them M charges on on Yak and on Shannon is because they were sitting in the room with Thug and he was finna, and he was the one that they wanted from the jump. They wanted to hold him accountable for those M's. And the way they was gonna do it was to send 2 people from YSL to jail for him. You know what I'm saying? They wanted that. Y'all gotta listen to Ed. Ed over here putting the pieces of the puzzle together.
I know politics. Here's the issue. Where's Thug stuff? Where all this stuff at?
Where is that watch? Where that watch at?
Where them cars at? Where the cars at?
They say it's a lot of other stuff that's missing too, y'all. More than the watch.
Right. Listen, man. I'm gonna put the whole puzzle together for you. Listen, put the whole puzzle together. Where is Thug stuff? You got in a case.
Well,
it was a lead case.
And then we will send out to everyone to take yet another look at these jury charges, including all the RICO we just did, the overt act crimes that we are just now including, and then hopefully everything edited correctly as to the rest of the charges. I think when we define the crimes that are just overt acts, they're not counts, that we need to set that off somehow. And I'll just kind of say, hey, you're going to get a list of alleged overt acts. And some of them are crimes. So I'm giving you the definition of those as well. Something like that.
I think that makes sense, Your Honor.
Okay. All right, so I know the state has provided a jury form that they're going to try to further tailor now that we have a better concept of how we're charging. And I know that was tedious to get through, but I think it was very important that we did it. And it kind of took everybody thinking it through to get to there. So I appreciate that from everybody. And whatever y'all come up with in the way of proposed verdict forms, just forward to Ms. Pressfield. We'll look at all of that. I know y'all need to know when we're going to start the closings. The only things we need, and y'all still need to put those stipulations together. Just pointed out that there are certain overt acts that are alleged to also be an act of, a gang act violation. And we've defined those overt act crimes, and we have sort of defined what a gang act violation is, but when we did that, we only did it with regard to the crimes that were substantive counts of the indictment charges. And there may be there's like an aggravated assault or something like that and other things. So
there's an attempted murder, there's a conspiracy for murder.
So we're going to need to.
Sales.
I think to keep it clean, instead of trying to
Still keep it separate?
Yeah, I think maybe we just
Okay.
the same thing except criminal gang activity. However, we have
For purposes of this, the overt acts includes, okay.
Do you have to do them? And I'm just saying, I'm throwing it out because the catch-all says any act of violence, drugs, it lists like the categories. I mean, an aggravated assault is clearly a violent crime. It's a suggestion to make it less wordy, but
I agree with Mr. Abadi.
Okay.
I think I do actually agree with Mr. Abadi. I think that when we're defining, I don't understand the need. I wasn't going to die on that hill, but I don't understand the need to specifically say
These things equate to.
Criminal gang activity, and that applies to when we defined it earlier and now. I think we can just the problem is the definition of criminal gang activity in statute is very long, and then it has the catch-all, and then it becomes
Yeah.
and then you're making references to different statutes as well. Like certainly I understand the crime of violence, but then there's the catch-all, and then we would have to reference the RICO statute.
Mm-hmm. And that just gets to be a nightmare. And so when we are doing it for the overt acts, what are y'all saying?
Everyone said it would take 2 years to earn an MBA. Everyone except WGU.
I like what Mr. Abate said, but I also think it's going to get cumbersome if we expect him to parse through everything. But So I would just do it the same way we did it in the first part and just say aggravated, what is it, aggravated battery? Aggravated assault, would constitute, if proven, would constitute criminal gang activity.
That goes out first agreement.
Yeah.
And where do you want that?
Well, I think if we cut and paste from the first part defining criminal gang or gang act, okay, and we put everything, we copied it and pasted it here as well for the charges for the overt acts, except when we have that little explanation of criminal gang activity, instead of putting murder and those other, we just put aggravated assault.
Can I make another suggestion? Your Honor, is your intention to read to charge on the overt act crimes first or second? Because my thought is, if we were going to charge on the counts first, you can maybe say criminal gang activity as previously defined, and then just put that last paragraph versus restating the entire charge, just saying criminal gang activity also includes this, and this, so that we don't have to say it twice. That may or may not be simpler, but I'm not sure.
Okay.
I think sorry, I'm interjecting, but I think the issue with that is the overt acts have to be with the RICO charges. Or we say something,
Yeah, I mean,
it could be later, but it has to be clear that these are related to, I mean, because it would, because the overt act is mentioned in RICO, and so it either needs to get restructured or we somehow refer back to.
Hey, that's the paychecks, Tay. That was the paychecks. That was the paychecks he just passed out. See how corrupt this is?
Or if you're doing the overt acts first, you don't have to repeat it the second time
I
when we're
kind of
talking
wasn't
about the
thinking
charge.
about doing the overt acts first.
I think my ultimate point was, I don't think we need
Yeah.
to repeat it twice. We can,
Right.
whichever time we do it, just refer back to.
Now remember, all this on
Are
record.
the
now.
gang
All of that is
counts
on record.
Mr. Kendrick and
So just imagine if it goes to appeal court.
So what I could say is, after we define it, for purposes of counts 50, 51, and 57, murder, blah, blah, blah.
I think the verb
Murder, possession of marijuana with intent to distribute, possession of a firearm during the commission of a felony constitute criminal gang activity. And then wherever we're doing it for the overt acts, say, for purposes of the overt acts, whatever they are, constitute criminal gang activity. Would that make sense?
Yes, we have another problem.
Okay.
One of the overt acts is section D of the criminal gang charges. That would be number 182, unless that is out.
Oh, maybe it's out.
I think that's the leadership. It's out. It's out. Yay.
Is it out? I doubt it. Oh, excellent. Okay. I just mean excellent in that it's one less thing we have to deal with. Okay. All right. Good catch, though, Ms. Persifield. So, thoughts as to whether I do the overt acts in the context of the gang, of the RICO count, or whether I just walk through, you know, here are the definitions, here's how you prove the substantive crimes, the counts in this indictment alleged against these defendants. And then after that, hey, there are also some crimes that are within the overt acts, crimes alleged within the overt acts. Here's how those are defined.
Maybe some sort of transition, like as you see in the indictment, or as you see in the indictment, count 1, RICO refers to specific overt acts, some of which are alleged crimes, and then I'm providing these definitions in regards to the overt acts list or something like that.
But here's my thing: reading the overt acts first is confusing as hell.
Well, the overt
It
acts are
was
not used
any
to
preference as
prove
to whether that's
a
done
punishment.
right after I
It's not,
explain
they're not
RICO
used
or
for
after I
anything
explain all
other
of the
than
substantive
to
count crimes.
enjoin the RICO conspiracy. They're not used for any other purpose because they don't carry an additional punishment.
Okay.
But what they do is solidify the RICO. You see?
Right. So why wouldn't you read the RICO charge, then read the overt acts? Like that
Because
would
they're ignorant. That's
Seems
why.
like-
They ignorant.
That's
That's why.
appendix.
They're
You
ignorant.
could say,
That's
you
why.
know,
No, all of the.
You don't know
everything
nothing. Let
I
me
read
tell you
is
about
go
this
out
guy.
to them.
No,
You
I
remember
wouldn't go out. I'm just
the
wondering,
mobs in New
the
York?
charges for the overt
You
acts,
remember all of
if you
them?
embed it in the middle of the document,
The mobs
right
in
after the
New
RICO
York.
section, or I think it may be more helpful to help them distinguish these from the acts and the count, is if you say, look in Appendix A,
Right.
and in Appendix A, you'll see how to understand the charges for the overt acts.
It's fine.
Is that okay with you?
Good idea. The state's nodding assent. Okay. Man, look at that. All right, so Ms. Persfield, you noticed something else?
We don't have in the overt acts firearm possession, because there's a number of counts for possession of a firearm by a felon. There's also a couple of counts for possession of a firearm by a probationer. And then we have the charges against the inmates.
The probationer one is the same, is the pattern that you use for possession.
Yes, substitute probation.
So we'll add that, but then there's several possession of a weapon by an inmate.
I mean, they just drawing stuff up and throwing it together. Look at this.
Conspiracy for possession by a phone by an inmate. And there's, I don't know if it's in or out, but the Ryan video while incarcerated.
Is that a crime?
I hate to say it, but the instructions are written for them to find them guilty of RICO, y'all. Like it is, especially with those overt acts.
Well, is that a crime?
It's written to find them guilty. I find it very difficult to believe that they get off on RICO.
Well, let me say this.
Yeah.
Have they shown in the trial anywhere? Have they shown where they proved that one of the defendants left the RICO? You know, the feds do that. They make sure you haven't exited the RICO. If you exit the RICO, then they make you an unindicted co-conspirator
crimes that
and
are
ask for your
overt acts
cooperation.
first,
right? Okay, so
within the
in this
context of
case,
RICO,
where you see where
I'm just
anybody
afraid
said,
that
I exited the RICO.
Nobody exited.
I don't know what I'm afraid of. It seems worrisome to me, and to some degree, that then that would be where they find the definition of things that they have to substantively consider against these defendants. You know what I'm saying?
My idea was if you use the appendix for crimes not otherwise defined.
Right. I agree with that.
All right, but then the order of it, I just don't think.
But who's the burden of proof on? The burden of proof is on the state. It's not on the defendant, it's on the state.
That's what I'm thinking.
Well, yeah,
They have to
it's
prove
at the end,
that you
Right,
didn't
but
exit
when
the
we-
RICO. And
when
the
we
trial
charge
fact
it,
should
when
know
I
that.
charge it, instead of
Oh.
saying, all right, now I've explained RICO to you, and now I'm going to tell you about the crimes that are overt acts here's how each of them is defined. I'm just going to say, I'm going to define those for you. If there are any, I'll just get to it later. And I'll do everything that's a count of the indictment. And then I'll say, you know, whatever I'm going to say. My brain's fried at this point.
Yeah,
But
thank you. I'm just a beat
RICO
behind right now.
refers to certain overt acts, some of which are crimes. Some of them have already been defined for you, others haven't. Here's the definition. Okay.
Okay.
Okay, what else?
So this is, so basically here under overt acts, this is in the RICO portion.
Doesn't it?
Right. An agreement.
I don't know. We'll figure it out tomorrow. You and I will figure it out tomorrow.
That's right. But
Are you saying put that language?
you see that last paragraph? Whether conspiracy, somebody exited the conspiracy. They have to prove that in the conspiracy, no one left the conspiracy.
Well, can't you
They
just
have to
put something in
prove
there
that,
before
not just say it.
the
They have to
appendix A for
prove that.
definitions of
Okay, yeah, an overt act may, but does not have to be a crime in and of itself. That would be the place to say that. Some of the overt acts alleged in this indictment.
That's what I mean. What's so crazy about the indictment? You see the way it's drawn up, Taylor. It's drawn up in order to
Some of the
lose.
acts alleged in this indictment.
I
if
100% agree with that.
proven,
The only person that I
would
think
be
that they could have probably, I mean, he thugged
criminal
Polo.
violations would be crimes.
I think they proved that he
if proven, would be
a long
crimes.
time ago.
Yeah.
Are you?
Yeah.
I'm not typing.
Now the guy, the RICO so-called expert, all he did was wrote a book. He wrote a book. He came up with when God in them, when John God in them had that organization, he made a way, he created a way to try them all at one time. And what he did was he tried a case with a gang.
I'm just going to highlight that and think about that tomorrow.
All right, beautiful people. I think that they are even wrapping up. Hey, said her brain fried. Y'all know I gotta go get my son off the bus. Y'all know I gotta go get Boosie off the bus. So thank y'all for tuning in today. We will be back tomorrow. I hope y'all have a good rest of the day, and I'll talk to y'all soon. Thank you, Ed. Everybody shout out Ed too.
Okay,
right?
great. I may
Ed
even say
has
that.
inducted into the telegang.
Have a
Thank you, Ed. We appreciate all your knowledge and input.
All right, look here. I'll see you tomorrow. I'll be here tomorrow. I ain't going back to work until it's over with right here. Because I want to see the ending.
All right, I may just say something.
I want to see how they get. I want to see how this get to the jury. Because the jury gonna come back and say, "Man, we don't know what we're doing." If they lost, then you know the jury gonna be lost. They're gonna say, "It's all." Keep this in mind. It's all about fairness. All about fairness.
Yeah, it may be tomorrow.
Yep.
Before that
I
gets
100% agree with that. And again, y'all, I will see y'all tomorrow. I gotta get my boy off the bus. Have a good night.
We'll
all right.
Get that tweet and get that over to the court and everyone as well.
Okay.